Tuesday, my lord, this coming Tuesday. I've informed Mr.
You
Sangma.
reinstated the person?
Tuesday,
Yes, yes,
positively, my lord.
Or you reinstated her also?
No, we have not reinstated, my lord. It was some, I don't know, Mr. Sangma has some, I don't want to say anything. But let it come up on Tuesday, my
I
lord.
have no information, Lordship. I have no instruction. Let it come on
Tuesday,
my
my
lord. Positively. Yes.
Positive or negatively, I don't know, but
Tuesday, my lord.
yes, after 1 week.
Hello.
Much better, Lordship.
Thursday.
Supplementary list, item number 1.
Yes, Mr. Kyle.
This is an appeal under section 268A of the Income Tax Act.
Yes.
The department prepared the appeal. Page 6 is the substantial question of law. Page 5.
1 second. Page 5.
Page 5. Where we have framed three substantial questions of law for consideration by lordship. First is challenge the jurisdiction of AO under the provision of section 124(3) of the Income Tax Act. Stated that no person shall be entitled to call and question the jurisdiction of the assessing officer. The lordship tribunal come to a finding that SSC has no jurisdiction under notification 1 of 2011. But section 124 subclause 3 says that it cannot, the jurisdiction of the assessing officer cannot be changed.
Yes. Anyway, we'll issue notice. That's the only ground.
No, there are 3 grounds, and
Yes.
another lordship one notification of 2011. That notification states about the income declared, not about the laws. So we have framed a substantial question of law for your consideration, lordship. Whether this notification will be, although the city inspection number 1 of 2011 regarding monetary for assessing cases to IO and DCS is referred to income declared, nothing mentioned regarding loss. And third question, lordship, an amount rupees 9,50,000 was not adjudicated by the tribunal, whereas the amount relating to accommodation entry received from sale company.
Right, okay, we'll issue notice. Yes. Heard Mr. S.C. Kyle, Leonard, counsel for the appellant. So issue notice. How many respondents? Only one. Issue
Only
notice.
one.
Yes. Issue notice returnable in 3 weeks. Yes. Just thereafter. Steps to be taken within 3 days.
Lots. Much better.
Daily list, item number 1.
Lordship, in this case, I have preferred an appeal. The judgment against the judgment, Lordship.
(30-10-24).
Lordship.
Past 6163. Yes. Yes. Yes.
Lordship.
Yes, we're waiting.
Lordship, actually, I don't know my.
You brought the wrong brief.
No, not wrong brief, but the copy of the judgment my colleague has not enclosed in my petition, Lordship. In my petition, I'm just.
So we'll dismiss the appeal.
Lordship, I have already served the copy, Lordship, to the opposite party. It may be posted for hearing, Lordship.
Yes, Mr. Day.
In pursuance to the judgment of this Honorable Court, my lord, Division Bench, my lord, this matter doesn't survive anymore, my lord. These are the judgments which will be passed by the learned.
She doesn't have the judgment of the case she's appealing against. Listed on next Thursday.
My lord.
Yes, for admission.
Item number 2.
That's a kind of work. What do we do with it? Yes.
My lord, I'm seeking adjournment for today as Mr. Ashish Bansal is out of station due to her daughter's admission process in Delhi right now.
You're supposed to file a rejoinder affidavit.
Lordship, the rejoinder affidavit is prepared, only the affidavit part has been left. So, Lordship, will grant the
2 weeks further time as per allowed for rejoinder, yes. Less thereafter.
Lordship, I am afraid to respond to the Lordship.
Very good. Yes, record his name.
Lordship, order is there.
Yes.
Item number 3.
Obliged.
Right.
May it please your lordship. Lordship, we have recently received for instructions, your lordship, in the form of Paravise, your lordship. Lordship may kindly grant us 2 weeks' time. Lordship will positively file our affidavit, your lordship.
Yes, sir. Mr. Arguing praise funds allowed for the 2 weeks or 3 weeks.
If your lordship can grant
3
us.
weeks time to file affidavit. This thereafter.
Item number 5.
Indian government 2 weeks not enough. Again, we have to.
Your Lordship, I pray for 1 week time to file the rejoinder.
Where's the Mr. Pandey? Where's Mr. Pandey? Yes, Mr. Group. Yeah, Mr. Pandey is Mr. Andrews Gupta. Please fund allowed. How much time?
Only 1 week.
1 week time to file the rejoinder. This thereafter.
Hearing item number 6.
Yes.
My lord, this is a petition wherein the virus of Kharagpur District Council market regulation is under challenge, my lord. On the ground that they have been leasing out the markets by issuing tender notices, and our case is that all these markets have been established by the NOCMAs themselves, and they are the members of the NOCMA Council, which is a petition before your lordship.
Who's the petitioner here?
NOCMA Council, my lord.
Is the registered body?
Yes, it is a registered body, my lord.
NOCMA Council?
Yes. So all the NOCMAs here, so they have been, the district council has been tendering the markets for collection of tolls from the market. So our grievance is that the district council has not established it, therefore...
This act is of which year?
1971, I think.
Then?
71. So, but still, my lord, so far as the fundamental rights are concerned...
No, one thing, are you challenging violation of the act?
Yes, my lord.
Or are you seeking some distinguish your markets from the prescription of the act. That is
that also can be done, but as the
whether you're challenging the provision of the act itself, the virus, or you're seeking to say that your markets
should not be interpreted.
Fall under the regulation. We have to be clear on that first.
Yes.
Yes. If virus, because 71 Act.
Yes. So far the power of
now 25.
But so far the power of the district council
Which provision is challenging?
Well, even starting from the definition, what I feel is the definition itself is wrong. That is why this problem is coming.
Yes.
The entire regulation is under challenge, my lord.
Okay.
I will not say the entire regulation because there are many things, but this regulation will apply as in Khasils.
They are not specifically said anything, but the entire regulation, it appears the entire regulation is under challenge.
Yes, please continue.
Yes, my lord.
Please proceed.
Well, if you come to page 236.
Page 36.
236 of this green book, my lord, of the district council.
You annex the act, correct?
We have annexed it, yes.
Annex.
Page 21, my lord.
Page 236.
21.
Yeah.
So here we come. The word market has been as clause 10.
Subsection 210.
Yes,
210.
Yes.
Yes.
It says that market means a place where persons are allowed to assemble either daily, bi-weekly or weekly for sale or purchase of foodstuff, livestock and other merchandise, and notified as such by the executive committee, and it includes haats and bazaars. So, my lord, this is the only definition of market. But how many kinds of markets will be there? This act is silent, and that's where this confusion has come. My lord, because according to para 6 of this 6th schedule, my lord, the law-making power of the district council, insofar as the market is concerned, my lord, paragraph 6, my lord, of the Constitution.
Yes.
It says, my lord, paragraph 6. It says, my lord, the district council for an autonomous district may establish, the word is may establish, construct or manage primary schools, dispensaries and markets. Means to say, it describes about 3 kinds of market, my lord, which is established by the district council, which is constructed by the district council, and which is managed by the district council. But in the act, only one definition has come, market. It does not say about the construction, about the establishment also. So in this connection, my lord, I will be short in the case. I will refer to the market regulation of the Khasils Autonomous District Council. So, my lord, I am from this.
Yes, I was going to come to that. Yes. Yes.
So it comes to definition portion number 2, page 387. Page 387 2E.
Yes.
It says district council markets. District council markets mean those markets directly established or to be directly established by the district council, and includes those markets under the management and control of the government of Assam until the district council took over, and also those markets, the management and control of which may be taken over by the district council under the regulation. So in this Kashmir District Council regulation, my lord, all those 3 points have been taken into consideration. That these are the 3 kinds of markets. Then, my lord, I come to
now you say
that there are 3 kinds of markets.
where you saying 3 kinds of
E, my lord.
and then Ileka markets.
Then comes, my lord, Ilaka markets.
Yes.
H. Ilaka markets are those markets established by and under the management of the chief and the darbar and recognized as such by the executive committee.
Right.
Which should say, it take into consideration the paragraph 6 of the 6th schedule, my lord. Then comes, my lord, L.
Market.
So this definition of market is same as in the Garhwal District Council.
Broad general definition.
Yes. Then comes, my lord, private market, N.
Yes.
Private market means a market established by and under the management of an individual or group of individuals, workers together, or of a firm, a municipality, a town committee, a corporation, or a department under the government and recognized as such by the executive committee.
Yes.
Then comes, my lord, Q, right market. Means a market established by and under the management of the right independent of the Ilaka and recognized as such by the district council. Then, my lord, comes S, the management. The management means an individual, body of individual, organization or authority responsible for the management of a market under the provision of the regulation and the rules made thereunder, duly recognized as such by the executive committee. So, my lord, these are the deficiencies in the Garhwal district. Had they defined it, the various kinds of the markets established by the district council, markets owned by the district council, markets managed by the district council, and the market established by the NOCMA or any private organization, then these problems would not have come. But now, whatever markets are there in the district council area, they are leasing out all, irrespective of the definition whether it is established by district council or not. In our petition, we have clearly stated that it was established by us. They have submitted a very exhaustive affidavit in position, but nowhere they whispered that these markets are established by the district council.
See, one thing, come to the core issue is that what you're seeking, Mr. Siddiqui, is for a direction to the legislature to enact certain provisions. Now, whether a writ court can do that?
No, I don't want that.
What if we understand correctly is that you not agree with the act per se.
Yes.
It's only with the definitions which you feel should have come in.
Yes.
To address different type of markets that are there, and so that is what do you call it? There's a proper kind of understanding and administration. That's all.
So now my case only is that when it is not clear and nowhere the district council has said, either in the tender notice or in their affidavit, that these are the markets which are established by the district council and are being leased out. So that is creating the confusion that all private markets are being leased out and they are earning from that, and those owners who have established the market are getting nothing from it.
So now just this management of these markets now, these NOCMA markets.
Yes.
Okay, or even these, are the management vests with whom?
With NOCMAs, because it is within the
market committee only,
yes.
Whatever is there.
Yes, yes.
So if it's in these NOCMAs, what role? They establish markets also?
Yes, they have established the market in their land, my lord, Aking.
They run and manage the...
Yes.
But then the leasing is done by
the district council. So they get nothing, and their land is being used for the purpose of the market. So there should be some way out. It can be settled if it can be managed, instead of going through all these constitutional provisions.
Yes, but the thing is that then you have to, this has to come by amendment. It's a question of setting aside the regulation.
Yes. So that much only it can be
now
done.
If you seeking to say that the markets that you have do not come with a definition of markets as per the this regulation, DC regulation,
yes,
then that we can examine. Otherwise, to seek a mandamus that the district council in its legislative capacity to enact certain provisions to
Yes,
we
it is
find
beyond-
markets
beyond the
adding
jurisdiction,
beyond
yes.
the scope of a writ
Yes.
court.
So only to that much that if they can consider.
Yes.
So that's all my letter friend.
Yes, Mr. Day.
My lord, first I would like to read out the prayer, what has been prayed before this honorable court by the petitioner. In the premises aforesaid, it is on page 14, my lord.
1 second. Yes.
In the premises aforesaid, it is most respectfully prayed that your lordship will be graciously pleased to admit this petition, issue rule, call for the record, and after hearing the parties, to set aside the regulation itself, my lord, the entire regulation. Second thing, my lord, to set aside the tender notice dated so and so. That tender notice has been expired. And my lord, a direction not to interfere in the management and affairs of the market belongs to the NOCMA of different arkings. Now, my lord, in the entire petition, my learned senior has not pointed out which are the market which has been established by the NOCMA. If I can divide Garo Hills, my lord, Garo Hills is into two parts, my lord. One is the hill area and the other is the plain area, my lord. Now they are saying that the entire Garo Hills market has been set up by them, my lord. There is nothing on record to show, my lord, that the market has been set up by them, my lord. Second thing, my lord, market can be
They
set
have
up.
not shown you one example of any market in any place.
No. There is nothing on record to show, my lord, that the market has been set up by them. They have made a statement, but there is no record to that effect.
The same thing here also. There is no record that they have established it.
We will show to it. Now, my lord, my learned senior has read out para 6 of the Sikh schedule, my lord, which empower the district council to establish, which may establish market, my lord. We have not established the market, my lord, as per para 6, my lord. Now, para 8 allow us, my lord, to assess and collect land revenue and to impose taxes. If my lord may kindly see para 8 clause 3, my lord.
Yes.
If my lord may kindly see, the district council for an autonomous district
Yes.
the district council for an autonomous district shall have the power to levy and collect all or any of the following tax within such district. This is to say, tax on profession, trade, callings and employments, tax on animal, vehicles and board, tax on the entry of goods into the market. We are collecting tax into the goods, my lord, which are entering into the markets for sale therein, and tool or passenger and goods carried in ferries, and the tax for the maintenance of the school. This is not relevant, my lord. Now, two things.
One thing, Mr. Day, what Mr. Dinesh, senior counsel, is saying is that you are leasing out these markets.
Leasing
There's
out?
no quarrel with your power under paragraph 82C.
Yes.
With regard to you imposing tolls on goods entering a market.
Yes.
Like we have little check gates now. This problem going on presently.
My
And, the tolls on animals, tolls on being sold to various markets.
My
It's not a question of one market. It's a question of entry of goods to a particular district where they be put up for sale. Yes.
My lord.
We are not leasing the market.
We are not leasing the market. We are, my lord, appointing the lessee for collecting tax which the goods are entering into the market, my lord. The tax is been imposed on the goods which are entering into the market. There's two different things, my lord. My lord, may kindly see the tender notice, my lord. Page, my lord. 29, my lord. Seal tender, non-refundable council court fee, sum of 50 rupees are invited from the interested party, person or parties for collection of tools, my lord.
Yes.
That is the tax, my lord.
No, see, by way of settlement of hearts.
Yes, my lord, because we have to settle, my lord. It has to be settled with some people. Now, we float the tender, my lord. People comes and participate in the tender process and they are selected, my lord. We cannot randomly give it to anyone, my lord, because as per the regulation, my lord. If my lord may kindly come to the regulation, my lord. That will be more clear, my lord.
One second. Let's read the tender because everything will stem from here.
My lord. 29, page 29, my lord.
Page 29, yes. You see, it's a question of tolls by way of.
Now, my lord, may kindly see. Serial number 11, my lord. Serial number 11, condition of the tender. The lessee should realize the tax from within the market area, my lord, as per the prescribed rate. So, whichever vehicles are entering with the goods, my lord, or a person entering with the goods, my lord, we are taking tax on that, my lord. And this, if my lord may kindly come to the regulation, my lord. Yes. Market regulation. Page 236, my lord.
Yes.
If I am permitted to read from the first, my lord. In pursuance of paragraph 11 of the Schedule to the Constitution of India, the following regulation of the Garo Hills District Council is hereby published for general information. The Garo Hills Autonomous District Market Tax Regulation 1970, passed by the Garo Hills District Council on 24 June 1970. The Garo Hills Regulation number 1 of 1971 received the assent of the Governor on 21st March 1971, published in the Meghalaya Gazette on 3rd April 1971. Now, my lord, what we are saying in the preamble, my lord, whereas under para 8 of the 6th schedule to the Constitution of India, the District Council of the Autonomous District is competent to levy and collect tax on the entry of goods into the market for the sale therein. If my lord may kindly again produce para 8 clause 3 of the 6th schedule, my lord.
Yes.
We are just collecting the tax on the entry of the goods into the market, my lord, which is sold in the market, and it is within the district council area, my lord. It is not out of the district council area that we have no jurisdiction. And this regulation has been published in the official gazette, my lord, as per para 11 of the 6th schedule.
No, of course, the legality of it's, there's no presumption of, constitutionality of every enactment which is published in Gazette. That is taken for granted. Not a question of your question constitutionality, but what they're saying is that there is a different premise altogether. That's the only thing.
What I could have understood, my lord, I'm open to be corrected by my lord, senior, my lord. They want an amendment to define market, but how they are aggrieved with this definition, my lord, they have not said anything. Moreover, my lord,
Mr. Siddiqui, one thing is that by writ petition, you have not, in fact, even addressed this question of what is your actual grievance. Well, the thing is that now you're talking about management of markets. Now, where have you shown in your pleadings that district council, by issuing this tender or allowing it, has impacted the management or control of the market in any manner?
This is in paragraph 26, my lord.
The thing is that you have to show instances. Yes, for the court to go, we have to go on hard facts. The question of just in the air that that fine, we understand. The power of the council to correct market tolls is there, but how it's affecting the management or the ownership of the market, That we don't know.
But in paragraph 26 of my writ petition, I read.
That is the problem. Because you see, if you challenge a virus of an act, the writ petition has to be crafted in such a manner that by itself also you give suggestions as to what is wrong with the legislation by dissecting every phrase. That's how you challenge legislations. We have done it before. It's not a question. It takes a lot of research to because you're challenging a legislation which has already been notified. It's not a simple matter, a simple petition where you're just crying for your rights. It's a question of violation of modern rights. So it's a question of getting the constitutionality, and you're saying that's ultra virus. The very basis of this ultra virus is the constitution, ultra virus, So where is para 20? Where have you get
Para 26, my lord.
26 where?
Of writ petition, my lord.
Page 12.
Page 12.
Oh, page 12, sorry.
That the above mentioned markets were all established by the Nokmas of various Akings in their respective Akings much before the establishment of the district council, and therefore the district council has no administrative jurisdiction to settle the markets with anyone by issuing a tender notice.
Yes, sir. No, they pointed submission that they are not settling any market. Market is yours. They just, because they're vested with what you call the power to levy tolls, they have settled those tolls.
Even in Shillong, my lord, we see this Yudu market is established by the City of Malim. That market, that settlement is made or lease is given to collect tolls by the CM himself, not by the district council.
But entry of goods, there's another checkpoint that the council have on different spots.
If I can just inject, my lord, in Khasi Hill District Council, I've done some research, my lord, on that. Khasi Hill District Council, my lord, they have established a market under para 6. And they are running.
No. You're on a different. You're on a different.
I'm saying
what Mr. Singh is trying to say, that for Barabazar market or cattle markets in the Khasi Hills, what happens to the owner of the market? Suppose he's a CM or the the retail head. He floats a tender, and the bidders come for collecting tolls within the market. Now there are two types of tolls. One, that is a CM's toll. The owner of the market charges those tolls by themselves. But another aspect is that you see there's a lot of talk now about those tolls of district council that they're being questioned as where they're being positioned, and they're judging this court, so you can't put them on the highways. You have to put them a side road.
Yes.
So those are the little toll, like revenue stations that have been set up as a council when the goods enter a district for sale anyway.
Yes.
Then that a nominal toll is charged on those goods. Like suppose 10 chickens or some vegetables. So that's what they take a toll. That is the toll that's taken under paragraph 8.
Yes.
But it's a council for Antipur district. Now what's happening in Garuls, from what I think we understand, is that for every particular market, instead of having one revenue station in some point entering the district, they are putting toll managers to collect tolls which entering the specific market.
Yes.
Whereas your rights with regard to leasing out the market, you can lease out to anybody. Where have you shown that they have prohibited you from, if you are a management, like you can give an example of some market. That is a market constituted by his king, and this is a management, that this is a society or committee that manages the market. Because there has to be a committee that manages the market to see how stalls are arranged, what section will sell meat, what section will sell vegetables. That's how markets manage.
On various
cleanliness, water supply.
That there is a clash of interest between the leases
and this is incompetent to address. I think we're not sitting advisory capacity, but you take a call. Otherwise, on this petition, I don't think any issues have been flagged at all.
My lord. My lord, I submit that.
So we'll reserve a judgment, or what should we
My
do?
lord, one more point just I want to add, that my lord, if they say they are not interfering into this market, if that is recorded, that will serve the purpose.
So why should we record that finding? When there are no pleadings, are all
They
in
are
the
saying
petition
that they are
too.
not interfering. Let it be
They're
recorded.
not saying not interfering. They're saying we're just carrying on a duty as vested in law upon them by paragraph 8C. That's all.
And they are saying that we are not interfering into the market. Let it be recorded. Then purpose will serve, my lord. Let them collect the tolls as per 8.1.
On the basis of pleadings, Mr. Siddiqui, we
But we
can't
have
even
said
come
in-
to those findings because you're not given one example of in one market that this is market.
We have given
A,
a
for
list,
example.
my lord, at
This is the copy paste of my tender.
No, have you given example? Okay, just name one market.
my lord, we have given the
Just
list of
name
all
one
the.
market, wherever situated, east, west,
yes, we have
south,
given, my lord.
southwest, name one market
It is there,
whereby
my
it's
lord.
being run by the NOCMA, a
Yes,
committee is
from
constituted.
so many years.
My lord,
Just
it is
name one market.
in page 31. It is there. The list we have submitted. That these are the market which are.
No, example of one market.
The detail of all the market we are given here.
But these are my tender notice,
No,
my
but-
lord. That settlement order that I have issued.
My lord, no, not that. It is
My lord,
page
may kindly
40.
see the list of West Garo Hills district, my lord, page 31.
Who's author of this document?
I am the author of this document, my
No,
lord.
my list of market in
Is
Garwell.
this issued by Secretary of the Committee?
Yes, my lord.
Annexure 4, my lord, please. It is not issued by them.
See, you bring materials, Mr. Siddiqui, to show that this committee is constituted, this market is being run by Mr. So-and-so.
From this year, it has been running.
My lord, this is there in page
We can't
40,
go-
my
we
lord.
can't
This is the
go-
copy paste of
My lord,
my
please
annexure
see.
3, my lord.
No, it is not so. My lord, please see page 40, annexure 4.
My lord, may kindly see the page, my lord.
No need to discuss.
Yes, yes, this is the copy paste.
Will you think about it, otherwise we'll close it for, we'll reserve for judgment.
Yes, all right, my lord. If your lordship can consider page 40 of my writ petition.
Is a copy paste of
annexure
page
4. No, it is
annexure.
not so. Just go through, my lord, once.
Hearing concluded, judgment reserved.
Hello.
Item number 7.
This is a case, my lord, of direction by the learned single judge to pay the scale of pay to temporary contractual worker of the same pay which is being received by regularly recruited employees, my lord, on the basis of equal pay for equal work, my lord. If lordship would recall, the order of the learned single judge is based on the premise that the casual workers or temporary workers are entitled to same pay scale which is being given to regularly recruited employees, my lord.
1 second. Another chapter. Sorry.
My lord, I have placed my written argument note of submission also. If your lordship would have that, because that will.
Type? Oh,
Yes.
when I'm sorry. I mean,
Note on.
I mean, oh,
Yes, your lordship has the note.
thankfully not a compilation because usually you give a,
Compilation.
I said, I want to say as a
Judgment
note
is
or a
already
compilation, not written. So usually you give a compilation which
No,
is
when there are
500
some.
pages.
No, my lord. Short is very short issue, my lord.
Yes.
The first point, my lord, is clubbing of multiple cause of action into one single writ petition is impermissible and renders the instant writ petition non-maintainable. So the case is, my lord, that if your lordship will see one paragraph of the writ petition, my lord, one paragraph of the writ petition,
Page?
and that paragraph is lordship will find at page 157. In paragraph 5, your lordship had at page 157. The members of the prisoners are appointed
in sanction post.
This is wrong, my lord. They have this is they themselves say casual also later on, but they in the writ petition subsequent paragraph they say casual, temporary, but here they say sanction post, which posts are also available in regular cadre, because there is a whole lot of difference when it comes to the meaning of what sanction post, my lord. And the nature and responsibility of the work are same for both, my lord. A comparison of posts between two and the nature and responsibility of work is illustrated here in below in the table format for brevity, my lord. Your lordship will see now name of the post held by the members of the union, Mali. Name of the post in regular cadre, Mali. Maintaining and look after office garden. Sweeper, cleaner, pump operator, chowkidar, my lord, etc. So they are about more than 30 posts or that have been set, my lord. Now the question is, my lord, the Mali who is part-time employee is discharging the same amount of work for same value of the work, then only he is entitled to equal pay for equal work, my lord. Filling which, for that the requirement in law is that the petitioner is required to place the material showing the nature of engagement, time of engagement, nature of recruitment, my lord. If he is recruited not regularly, then he is not entitled to the salary which is being given to the regularly recruited candidate. That is the law, my lord. So this way, my lord, my first submission which I was taking, that if the case of the petitioner is that Mali who is holding the temporary post, and he is equal, and his work and everything is equivalent to the post held by someone in regular cadre is same, he has to produce the material in the form of recruitment order, the work order, the job duties in respect of Mali. So he cannot club Mali, sweeper, cleaner in one writ petition, my lord, because the cause of action for Mali will be different, cause of action for sweeper will be different, my lord, because each issue has to be gone into and identified, my lord. For example, my lord, I just place one order which has been placed regarding the employment of sweeper, etc., my lord. Kindly see page 269, because typed copy 269, my lord. Lordship will, in the interest of both, Sri Ram Singh is hereby appointed as part-time sweeper in the establishment of Superintendent Engineer Shillong, so and so, my lord.
Is he one of the petitioners?
Yes, my lord. They are all petitioners here, my lord. Members of the association, my lord. They are all
the member
of the association, my lord. Now, part-time, my lordship has noticed, and incumbent consolidated pay so and so. Lordship will find 271, my lord. Again, so they are being appointed on part-time basis, my lord. But that issue may not be required to be gone into, whether, because first the onus is on the petitioner, my lord, to show that the members of the association belonging to sweeper category or post held by them are discharging the same function as one who is regularly recruited, my lord. So that is the first requirement of law, my lord. And therefore, if your lordship kindly come to my submission, first submission, it is submitted that present writ petition is not maintainable because the petition has clubbed different alleged cause of action of different persons. Paragraph 1, my lord.
Yes.
Are working on different posts, and the same cannot be decided by way of single writ petition. It is submitted that present concerns various persons working on 31 different posts, that is Mali, sweeper, etc. The facts concerning each post is different, and same cannot be clubbed into one single writ petition. Since each writ petition has different cause of action, same cannot be prosecuted by way of single writ petition, my lord. 2, my lord. It is submitted that each of petitioner has distinct cause of action against action of the appellant and the respondent of whether they are entitled to equal pay or par with regular employees will be determined only after evaluating the existence of wholesome and wholesale entity between the holders of two posts. For any such exercise to be carried out, the respective person is required to demonstrate the source of entry, the qualification possessed, manner of recruitment. In the present case, an omnibus statement has been made by the Petitioner Association regarding equality in all respect without placing any material in support of the said assertion. Rather, material is contrary to the assertion, my lord. The relevant judgment in this regard are quoted, my lord. The three judgments I rely, my lord. Last time I placed these judgments also before your lordship. First, in the case, all the writ petitioners who are working in para teachers are claiming their respective absorption in the service of permanent regular. In our view, all of them are claiming their individual rights and there is no zero relations between writ petitioners. Their cases can be of a similar interest but is not of a common interest. A mandamus has been sought for their individual absorption in service. It cannot be held that they are pursuing a common and joint interest or a class as a whole rather than pursuing their own interest. Therefore, it has to be understood that they are pursuing their individual relief. Although they may have similar interests, in our considered view, the petition shall be deemed to have been presented on behalf of each of the petitioners separately. If each of the petitioners has similar interests, they may be allowed to present joint petition, but for the purpose of payment of court fee, they would be required to pay separate. It is not the case that the relief is granted to one of the petition, then all the petition would be benefited automatically. Actually, separate orders of authority would be required to be passed for their absorption considering the individual cases. Thus, in the present case, separate case of court fee is required to be filed by the petitioner. The point, my lord, I am trying to make is, my lord, in respect of 31 category of, if they say that they have the wholesome and wholesale entity common between the regularly recruited Mali and temporary Mali, my lord, their case will be on different footing. Similar is the judgment, my lord, in second judgment, P. Radhakrishnan Naidu versus Government of AP 1977, 1 SEC. Further, it has to be observed in the presented petition, several petitioners have combined as petitioners. Their cause of action are separate and independent. Each is alleged to be instance of individual assertion of constitutional right. In regard to facts and circumstances of each case, where several petitioners combined for alleged violation of their right, it is difficult for the court to go into each and every individual case. In the present case, the affidavit evidence is preferred and therefore first petitioner cannot agitate the question of disputed date of appointment. Third, my lord, Mota Singh versus State of Haryana. We therefore of the opinion that office should scrutinize afresh each one of the cases referred in the office report and ascertain whether requisite court fee has been paid by. In ascertaining the fact, the office should ascertain whether there are number of petitioners who are combined in one petition, the position of each the co-petitioner and the relief claimed, and determine the liability of each such petitioner to court pay fee, my lord. So the idea is, my lord, that if you are having an independent cause of action which is common to Mali, my lord, you will maintain a separate petition for Mali, demonstrating that Mali who is regularly recruited and Mali who is recruited on part-time basis, they are performing identical work, they are performing the work of same value, then possibly, my lord, writ petition is maintainable. But in this form, writ petition is not maintainable. This is my first objection, my lord. Now, second objection, my lord, is with equal pay for equal work, my lord. That judgment, my lord, I just want to place because this is a recent judgment of 2023 SSC Online SC 173, my lord. The facts of the case, my lord, in brief, is in paragraph 5. That main question that falls for consideration before this court is whether tribunal and the High Court were justified in equating posts of JDOs and CTOs in fixing the pay scale of JDOs equivalent to that of CTOs, and in utter disregard of illegal proposition settled by this court in Catanov decision to the effect that court should not interfere with the complex issue of evaluating the nature of duties and responsibilities of post and of fixing pay scale, which task otherwise is best done by the expert bodies like pay commission, my lord. And after recording the arguments of the parties, my lord, the Honorable Supreme Court, my lord, in paragraph 9 takes note of the various case laws. Before adverting, paragraph 9, my lord, to the rival contentions raised by the learned counsel for the parties, it deserves to be noted that the power of judicial review of the High Court in the matters of classification of post and determination of pay scale is no more res integra. It has been consistently held by this court in plethora of decision that equation of post and equation of salaries is a complex matter and is best left to an expert body unless there is a cogent material on record to come to a firm conclusion that grave error has crept in while fixing the pay scale for a given post, and the interference of court was absolutely necessary to undo the injustice. In the state of UP versus JP Chaurasia, while answering the question as to whether bench secretaries of the High Court of Allahabad were entitled to pay scale admissible to the section officers, and whether the creation of two grades with different scales of in the cadre of the bench secretaries who were doing the same and similar work was violative of right to have equal pay for equal work, this court observed as under. The first question regarding entitlement to the pay scale admissible to section officers should not detain us longer. The answer to the question depends upon several factors. Your Lordship may kindly mark this on several factors. Does not detain, the answer to question depends. It does not just depend upon either the nature of work or volume of work, my lord. Nature of work or volume of work done by bench secretary. Primarily, it requires, among other things, evaluation of duties and responsibilities of the respective post. More often, function of two posts may appear to be same or similar, but there may be difference in degree in the performance. Quantity of work may be the same, but quality may be different. That cannot be determined by relying upon averments in affidavit of interested parties. The equation of post or equation of pay must be left to the executive government. It must be determined by expert bodies like pay commission. They would be the best judge to evaluate the nature of duties and responsibilities of post. If there is any such determination by commission or committee, the court should normally accept it. Court should not try to tinker with such equivalence unless it is shown that it was made with extraneous consideration. Paragraph 11, my lord. The aforestated ratio was followed by this court in Union of India versus Makhan Chandra Roy, again in Secretary Finance versus so-and-so. The claim of Sub-Registrar of West Bengal Registration Services claiming parity in pay scale with Munsif on the basis of Sub-Registrar where conferred gusted status were examined by the court. It was elaborately observed in Para 12 as under. We do not consider it necessary to traverse the case law on which reliance has been placed by counsel for the appellant, as it is well settled that equation of post and determination of pay scale is the primary function of executive and not the judiciary, and therefore ordinarily courts will not enter upon the task of job of evaluation, which is generally left to the expert bodies like pay commission. But it is not to say that court has no jurisdiction and aggrieved employee have no remedy if they are unjustly treated by arbitrary state action or inaction. Court must, however, realize that job evaluation is both difficult and time-consuming task, which even expert bodies having assistance of staff with requisite expertise have found difficult to undertake sometimes on account of want of relevant data and skills for evaluating performance of different groups of employees. This would call for constant study of external comparisons and internal relativities on account of changing nature of job requirement. Factors which may have to be kept in view for job evaluation may include work program of his department, nature of contribution expected of him, the extent of responsibility and accountability of discharge of his diverse duties and functions, the extent and nature of freedom limitation available to or imposed on him in the discharge of duties, the extent of power vested in him, the extent of his dependence on superiors for the exercise of power, the need to coordinate with other departments. We have also refer to the history of service and efforts of various bodies to reduce the total number of pay, my lord. And thereafter your lordship will after that 5 line, while doing so, care must be taken to ensure that such rationalization of pay scale does not throw upon anomaly. Ordinarily, a pay structure is evolved, my lord, method of recruitment, etc. Paragraph 12, my lord.
Yes.
My lord, I have in my note, what I have done is, my note, I have highlighted the relevant part of the judgment, my lord, of this judgment of Union of India, and culled out and put it under bold also, my lord, for the convenience of the court, my lord. And kindly see at page 8, my lord, page 8 of my note, where page 8 where I have highlighted, my lord, a mere nomenclature, because here your lordship is concerned with the nomenclature, Mali in regular post, Mali in temporary post, my lord. Paragraph 8 of my note, your lordship may kindly see. A mere nomenclature designating a person to say as a carpenter or craftsman is not enough to come to the conclusion that he is doing the same work as another carpenter or craftsman in regular service. The quality of work which is produced may be different, and even the nature of work assigned may be different. It is not just a comparison of physical activity. Application of the principle of equal pay for equal work requires consideration of various dimensions of a given job. The accuracy required and dexterity that job may entail may differ from job to job. It cannot be judged by the mere volume of the work. There may be qualitative difference as regard reliability and responsibility. Functions may be the same, but the responsibilities make a difference. Thus, normally, applicability of this principle must be left to be evaluated and determined by an expert body. These are not matters where writ court can lightly interfere. Normally, a party claiming equal pay for equal work should be required to raise a dispute in this regard. In any event, party who claims equal pay for equal work has to make necessary averments, my lord, and prove that all things are equal. Your lordship may kindly mark. Thus, before any direction can be sued by court, the court must first see that there are necessary averments and there is a proof. If the High Court is on the basis of material placed before it convinced that there was equal pay for equal equal work of equal quality and other relevant factors are fulfilled, it may direct payment of equal pay from the date of filing of respective writ petition. In all these cases, we find that High Court has blindly proceeded on the basis that doctrine of equal pay for equal work applies without examining any relevant factors. In Union of India versus Secretary Department of Personnel, so and so, the court reiterated the said position. The classification of post and determination of pay structure comes within the exclusive domain of executive, and tribunal cannot sit in appeal over the wisdom of executive in prescribing certain pay structure and grade in particular service. There may be more grades than one in particular service. 14. In view of the aforestated legal position, it clearly emerges that doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in a court of law. The equal pay must be of equal work of equal value.
Yes.
The equation of post and determination of pay scale is the primary function. So this is the point, my lord. And then next judgment also, my lord, is that state of MP versus R.D. Sharma, my lord, page 10, my lord.
Yes.
This court has consistently held that equation of post and determination of pay scale is the primary function, my lord, same aspect which has been. Now, there are disputed questions also, my lord.
Yes.
Which that we have disputed that the temporary employees are discharging the same functions as of the regular, and therefore, in my humble submission, writ court could not have examined this aspect where there are certain disputed question of facts, which is my next point, point C, my lord, of page 10. Then, my lord, the judgment which is relied upon by the learned single judge.
Yes.
In that,
if you
yes, my lord. That, my lord, with respect, my lord, the learned single judge has not correctly appreciated this ratio laid down in this judgment, my lord. And kindly, for the sake of convenience, my lord, kindly see my paragraph D. That it is submitted that the exercise of establishing wholesome identity A post and equivalence of work done by the persons working on two different posts is complex factual exercise where the petitioner must plead and prove the equivalence. It is submitted being an exercise involving disputed question fact. The said exercise is best left to the executive. However, be that as it may, in the present case, there is no evidence to show that all 31 posts are equal to any post held by regular employees. In this regard, it is submitted reference may be made to the judgment of so and so, because learned single judge has referred. Your Lordship will see paragraph 9.1. The petitioner in the above case were personal assistant and stenographer attached to the Department of Custom and Central Exercise, Ministry of Finance. They are placed in equal scale of so and so. Petitioner claims that basic qualification, method and manner of source of recruitment and their grades of promotion were same as of their counterparts attached to joint secretaries and other officers of central government. The above counterpart, it was alleged, were placed in the pay scale of 650 to 1040. Petitioner contention was that their duties and responsibilities were similar to duties and responsibilities discharged by some of the counterparts. Premised on this instant finding, it was their contention that differentiation of their pay scale was violative of Article 14. Petitioner claimed equal pay for equal work. The assertion made by the petitioners were repudiated by Union of India while acknowledging that duties and work performed by petitioners was identical to the performed by the counterparts attached to the joint secretaries to other officers in the yet it was pointed out that counterparts working in the secretariat constitute a class which was distinguishable from them. It was asserted that the above counterpart discharged duties of higher responsibility as joint secretaries and directors in the central secretariat perform functions and duties of greater responsibility as compared to head of department with whom the petitioners were attached. My lord, a temporary employee, my lord, if I apply this ratio, temporary employee may not be discharging. He is not discharging, in fact, my lord, same kind of responsibilities which is being discharged by the regular employees. It was contended that principle of equal pay for equal work depend on nature of work done, not on mere volume and kind of work. Respondent also asserted people discharging duties and responsibilities were qualitatively different when examined on the touchstone of reliability and responsibility could not be placed in the same pay scale. So temporary worker, my lord, and the regular worker, my lord, your lordship, that knows paragraph 9, while adjudicating upon the controversy, this court arrived at conclusion that differentiation of pay scale was not sought to be justified on the basis of functional work discharged by petitioners and their counterparts in secretariat, but on dissimilarity of their responsibility, confidentiality and relationship with the public. Even assuming, my lord, that they are discharging the same amount of job, but if the responsibility etc. is different, my lord, they are also, the Honorable Supreme Court has held that they are not also entitled to the same pay, equal pay for equal work. It was accordingly concluded the same amount of physical work could entail different quality of work, some more sensitive, some requiring more tact or some less. It was therefore held the principle of equal pay for equal work could not be translated into mathematical formula. Interference in claim as one projected by petitioner at the hand of court would not be possible unless it could be demonstrated that either differentiation in the pay scale was irrational or based on no basis or arrived at malified either in law and fact. So these are the parameters on. In the light of this stance adopted by respondent, it was held that it was not possible to say that differentiation of pay in present case was not based on rational nexus. It is in the above matter prayer was declined, my lord. My lord, after 10.1, 10.3, my lord, page 13. While answering the first question, this court felt that the issue required evaluation of duties and responsibilities of the respective posts with which equation was sought. And it was concluded that on the subject of equation of post, the matter ought to be left for determination of to the executive, as the same would have to be examined by the expert body. It was, however, held that whenever it was felt that expert body had not evaluated the duties and responsibility of concurrence law, matter would be open to judicial review. In the present case, while acknowledging that at one time bench secretaries were paid more emolument than section pay, it was held that since successive pay commission even rationalization officer perform more onerous duties bearing greater responsibility, it was not possible for this court to go against the said opinion, as this court reiterated pay of the branch secretary is assigned to so and so. The consideration, my lord. Now this is the conclusion, some of the conclusions which have been relied upon by learned single judge. All the judgments noticed in para 7 to 24 here and above pertain to employees engaged on regular posts who were claiming higher wages under the principle of equal pay for equal work. The claim raised by such employees was premised on the ground that duties and responsibilities rendered by him were again the same post for which his higher pay scale was being allowed in other government departments, or alternatively, their duties and responsibilities were the same as of their other posts with different designation, but they were placed in lower scale. Having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay for equal work was invoked and considered, it would be just and appropriate to delineate the parameters laid down by this court. In recording the said parameters, we have also adverted to some of the other judgments pertaining to temporary employees also dealt with in the instant judgment, wherein also this court held that had the occasion to express legal position with reference to the principle of equal pay for equal work. Our consideration has led us to following deductions. First, 1442.1. The onus of proof of parity in the duties and responsibilities of subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it. My lord, my friend has miserably discharged his duties. He who approaches the court has to establish that subject posts occupied by him require him to discharge equal work of equal value. My lord, kindly mark the as to the reference post. So that has to be pleaded, proved, argued in the writ petition, my lord.
This is there in the judgment Jagjit Singh.
Yes, my lord.
42.1.
42.1.
Let's see the judgment.
Yeah, it is already annexed with my petition. Your lordship, kindly come to page 434. 434.
434.
Yes, my lord. And the conclusion is the conclusion part which I am reading, my lord. My friend is also relying on this judgment. 42.1, my lord.
Consideration.
Yes, my lord. I have read 42, my lord.
Yes.
Page 492. Because I have culled out the relevant paragraphs, my lord. Then, my lord, 42.1, onus of proof, my lord, I have shown. Then 42.5, I am referring to, my lord. In determining the equality of functions.
Yes.
In determining the equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that duties of two posts should be equal sensitivity and qualitatively similar. Differentiation of pay scale for posts with difference in degree of responsibility, reliability, and confidentiality would fall within the realm of valid qualification. Therefore, pay differentiation would be legitimate and permissible. See Federation of All India Customs and Central Excise and SBI. Nature of work of the subject post should be the same and not less onerous than the reference post. Even volume of work should be the same and also the level of responsibility. If these parameters are not met, parity cannot be claimed under the principle of equal pay for equal work. And then 42.6, my lord, for placement in a regular pay scale, the claimant has to be a regular appointee, my lord. That is the sine qua non, my lord. The claimant should have been selected on the basis of regular process of recruitment. I have shown, my lord, the appointment letter. An employee appointed on a temporary basis cannot be claimed to be placed on regular pay scale. Nothing more I am required to show, my lord. But 42.8, if the qualification of recruitment to the subject post vis-a-vis the reference post are different, it may be difficult to conclude that duties and responsibility of posts are qualitatively similar or comparable. In such a case, the principle of equal pay for equal work cannot be invoked. My lord, nothing has been placed. What is the qualification of the carpenter, mali, etc. And then 42.14, my lord. For parity in the pay scale, under the principle of equal pay for equal work, equation in the nature of duty is of paramount importance. If the principal nature of duties is one post is teaching, whereas that of other is non-teaching, principle would be non-applicable. If the dominant nature of the duties of one post is of control and management, where subject posts have no such duties, principle would not be applicable. Likewise, if the central nature of duties of one post is of quality control, whereas the subject post has minimal duties of quality control, principle would not be applicable, my lord. 42.15. There can be there can be valid classification in matter of pay scale between employees even holding posts with same nomenclature. That is between those discharging duty at the headquarters, other working and institutional, etc. So simply because, my lord, nomenclature is one and the same, my lord,
will
not be suffice unless he meets all these parameters, my lord. Paragraph 7 of my note may kindly see on this point. It is submitted that aforementioned conditions lay down the onus of proof on the petitioner which is not satisfied by the petitioner in the present case. Very short petition, my lord. I will read that petition also. It is also submitted that persons who were not regular employees were appointed on purely temporary basis. A perusal of the office order establishes the same. For instance, the office order dated 31st May at page 131 clearly established that the above engagement is purely on temporary basis and may be terminated at any time without assigning any reason. Thus, the nature of appointment and duties assigned to the person who represents petitioner association is entirely different. Paragraph 8. It is submitted that judgment in Jagjeet Singh was passed in the context of the fact that the state of Punjab had admitted that there has been complete identity of posts, duties and work undertaken by petitioner and referred posts, and in that case and to referred posts. However, it is not the case in the present case, my lord. Now, paragraph 9. Appellant has categorically denied all the claims of petitioner in the counter affidavit, particularly in page 10 under the heading writ petition is based on incorrect facts, and page 11 under the heading writ petition is barred by law. The following points are raised. Petitioner has not disclosed that appointments are made in respect of members of petitioner associations. All are contractual hires and who are had more than sanctioned post. Post of electrician, meter reader, complete and Jugali post, and who are the maximum number of the union, are being recruited beyond the sanctioned post purely on need basis, depending upon requirement of job and jurisdiction. Hence, the claim of petitioner is false and baseless. C. Petitioner cannot draw parity between nature of appointment and payment in other department authority because MUDA or some department comparison was. Since the inception of corporation, it has been giving the power to set its own rules and regulations, and therefore claim made by the petitioner has now bearing relevance. Petitioners claim that the service regulation of the corporation is also applicable to contract is false, incorrect. However, it is only terms and conditions provided in contract employment that is binding upon contractual employees. Has failed to disclose many contractual employees were appointed for a period of 1 year based on contract appointment, my lord. Now, so far as the benefit, my lord, appellant corporation has taken a step for the benefit of contract. Appellant had taken that enhancement of increment of salary with effect from 2000 based on experience and tenure of casual employees. Percentage of enhancement 5 years but below 10 years 5% total minimum wages. The percentage of enhancement of wages 10 years below 10% percentage of enhancement. Furthermore, additional benefit have also been extended to welfare of employees who are mentioned provident fund coverage under the terms of casual leave, earned leave, etc. C. Several actions have been taken by corporation in interest of welfare of contract. Those are the welfare measures we have taken, my lord. Now, if your lordship will kindly see the writ petition, what is the pleading before your lordship, and then I will place the impugn order, my lord. Writ petition starts from page 151, and the relevant page your lordship will see at page 155. Union, this is by Progressive Union, my lord. His resident is registered so and so. About 1500 or 1700 members are there, my lord, of Union. There. Then your lordship will see the pleading, my lord. Paragraph 4, my lord, is some pleading is there. It is submitted that since the inception of petitioner, the union have been tirelessly working the every possible way for welfare of members by placing various charter of demands, including equal pay for equal work, which is the issue instance. Various memorandum meetings have been taken place, and management of the responsibilities have failed to bear the fruits. Dharnas, agitation, etc. My lord, this is not relevant for the issue of equal pay for equal work. My lord, 5, my lord. The members of petitioners are appointed in sanctioned post, my lord. Where is the material? I have said they have which posts are available in regular cadre. The nature and responsibility of work are same because sanctioned, roster, everything will apply. Recruitment, advertisement, my lord. And the only common thing your lordship will find in paragraph 5 is Mali and Mali. Sweeper and sweeper, LDA, etc. my lord. And then paragraph 6, my lord. The petitioner states that they are appointed against posts available in regular cadre, performing similar duties and responsibility as being discharged by regular employees, holding same or corresponding post, no only mere averment, my lord. It is humbly submitted, even though they are performing same nature of work, have discriminated when it comes to paying wages. The comparison of pay scale of Meghalaya Energy Corporation pay regulation between the members of and regular employees, my lord. Now, for example, my lord, if your lordship will see designation clear in Mali, there is a pay scale and the monthly salaries which are being paid unskilled 340 into 30 days 10,290 plus increment etc. my lord. So this is the chart they have placed, my lord. Now paragraph 7. Now here what is being said, they are appointed as casual employees. Earlier, my lord, regular employees in previous paragraph. Here in paragraph 7, casual employees and terms and conditions of service made applicable to them. So all these service jurisprudence connotations, sanctioned posts, regular posts, casual employees have got different legal connotations and meaning, my lord, and they have been interchangeably used to in humbly submitted pursuant to the chart of demands, my lord. And then there are after there is no material. If your lordship will see next 2 pages also, there is nothing to show, not an iota of material. Now kindly come to the impugn order, my lord. At page 32.
There's only pleadings made entire petition.
Yes, my lord.
With regard to similarity of posts.
Yes, my lord. Nothing. And they are admittedly not regularly appointed, my lord. The learned single judge, my lord, has relied on Jagjit Singh, but Jagjit Singh is in my favor.
Yes.
If your lordship will kindly see, and the learned single judge have recorded my argument, held that those are valid. But if your lordship will see, but the paragraph page 32, my lord, and the
page 32
of the paper book, my lord.
So the impugned judgment.
Impugned judgment, my lord. And then the submissions of my submissions of learned friend are recorded, my lord. Same thing what has been stated in the writ petition, my lord. Now his reliance on these paragraphs at page 8, paragraph 8 at page 36, my lord. And my arguments, my lord, is paragraph 11. Page 37. To clarify, the learned counsel has led this court. Now, if a lordship will see paragraph 10, in the present form, wherein it is noted that petition has been filed on number of petitioners, albeit being members of petitioner, but with different cause of action, where each would seek relief a specific set of facts and situation, and facts cannot be clubbed together in a single writ petition. To clarify this, learned counsel has led this court to para 5 of the petition, where averment has been made that members of many members of the petitioners were appointed in the sanctioned post, which were not. A comprehensive table listing the name of post held by the members of also post in the regular grade has also been shown. However, facts concerning each post is different and cannot be clubbed together, my lord. This is my submission noted. 12, my lord. Incumbent upon the union in matter of individual employees for making out a case at parity between 2 posts, there must be a wholesale identity between the holders of 2 posts, for which respective person is required to demonstrate the source of entry, qualification, purchase, manner of recruitment, which is lacking in the petition, as only omnibus statement is made. Now paragraph 13, my lord. Another limb of argument advanced by the counsel is that petitioner union briefing has failed to present correct factual matrix. Case of petitioner union who were appointed beyond the number of sanctioned posts on need basis. Example of such posts as electioneer, etc., Jugali worker, pay, etc., labor. The pay which are being fixed on the basis of notification issued by Labour Department, Government of Meghalaya in line with minimum wages, depending upon skill and ability. In fact, in addition to payments, so and so, my lord, if the order of the learned single is upheld, my lord, I will not have right to appoint anyone on contractual pay scale, because if I am appointing a driver in my organization, I will have to give him the minimum pay scale.
Only one thing, these petitioners, they have signed a contract also.
They are,
I saw that,
they are temporary workers,
after their
temporary sweeping, etc. So, my lord, now there has to be pleading that I have this appointment letter. I have to perform the job from 10 to 5. This is my duties and assigned to me. And if I have shown, my lord, and then the regular sweeper is having this type of job, then only he can, my lord. And then paragraph 14, my lord, the judgment which I placed was referred by learned single judge.
Yes,
That has been
Navy civilian.
yes, my lord. That judgment, my lord, was also noted. All these after noting paragraph 21, where the 21 where the distinction was attempted to be made by learned single judge on consideration of the proposition propounded by MCL, where stress is laid on the aspect of equal pay posts of determination of pay scale, which requires proper classification best left to the expert body. This court is made aware that case of petitioner is not for equation of post or determination of pay scale connected, but already existing same category post of cleaner mile. Now, my lord, if the error has come in, my lord, that it is a case where you are claiming that I am discharging the functions of Mali in regular cadre. You are saying that my post is equivalent to post of Mali in regular cadre. That is, without that you will not be entitled to pay scale. And there the learned single judge, some mind by implies who have been that there are already exist same category of posts, my lord. Posts may be same, but the nature of job, recruitment, etc., everything is different. What is last three line? What is evidence that there are two classes of employees, one regular and other temporary, performing same nature of work, my lord. I don't know on what basis learned single judge has reached to this conclusion. Two different set of pays, because there was no material placed, and based on the chart drawn from the petitioner in para 6, my lord, that is not adequate material in my humble submission, my lord. Paragraph 22 has further contended the petitioner filed representative is not maintainable, my lord. And this is, and then your lordship, the relevant paragraph of Jagdish Singh at page 42, page 44, paragraph 5, 25. I am reading from page 44, paragraph 25, where Jagdish Singh's judgment has been, certain relevant paragraphs have been, Jagdish Singh have been referred to, but the learned single judge has not taken note, my lord, of the paragraphs which have been pointed out in the judgment where the ratio has been laid. Those paragraphs your lordship has seen. I have placed 42.1, my lord, that has not been taken note by learned single judge. Then 42.5, my lord, 42.6. And in totality, my lord, Jagdish Singh is in my favor, and paragraph 26 where the conclusion is. Regularization. It's not a question of regularization, my lord. Whether they are entitled to equal pay for equal work or not. And therefore, the judgment of the Jagdish Singh is in my favor. The learned single judge, in my humble submission, has not correctly appreciated the ratio of Jagdish Singh, my lord. In view of the above, my lord, my submission is that my writ appeal should be allowed. My one submission, my lord, if your lordship will see that there were 1700 casual workers, meter readers, my lord, if the principle of equal pay for equal work is applied to them, my lord, because sometimes they are doing only meter reading for certain things, my lord, the financial condition of the corporation will collapse, my lord, and survival will be at stake, my lord. That is on equity, my lord, not on law.
That's it. How long will it take?
My lord, half an hour. My lord, what boils down to all this argument and the citations, my lord, is that the burden of proof is on me. And it says that in my writ petition, I have not pleaded in what manner I am doing equal work, the quantity of work, the time that has been put, my lord. Paragraph 5 of my writ petition, my lord, which my learned senior has read twice before, my lord, where we say that
upon a sanction post.
Yes, on a sanction post, and we are given the post also now. In the counter affidavit, my lord, they have admitted that. So under section 58 of the Indian Evidence Act says, once a fact is admitted, you need not further prove anything else. That is the law. So therefore today, on this ground, they are stopped, my lord. Keeping
the affidavit where they've said where they admitted.
Yes, my lord. I'll just page 380, my lord. Page 380. before that, my lord, may kindly come to page 378. That is the para-wise reply, my lord. So when we are talking about para 5, my lord, para 1 here, it says that is a no need to merit no response, my lord. Para 2 is a response to para 2 of my writ petition, my lord. Then it goes on, my lord, and then, my lord, it goes to para 4 in page 80, my lord. They went straight away to reply to para 6 and para 7, my lord. Para 6 and para 7. Now, my lord will recall, at para 5 of my writ petition, I said our members have been appointed on contract or on a sanction post.
On affidavit also, you said in one para you say to a sanction post. Next para you say casual.
Yes,
so
of course.
You also have not made up your
mind.
No,
we are appointed as a casual workers in a sanction post.
Where's the averment you made in the petition?
My lord, that is
categorical averment that they were appointed against vacancies in a sanction post. Because we're looking at that now. If you appoint against vacancies sanction
my lord,
post,
then
or whether you appointed over above sanction post in a casual capacity.
Then my lord has to conjointly read these two paragraphs, my lord.
Another thing, Mr. Yubin.
My lord.
Again, we'll come back to the query we put much earlier on also.
Yes, yes.
Whether there was any selection process adopted when you were selected?
I'm sorry?
Was any selection process adopted when you were appointed?
My lord. My lord.
What the rules?
The law, my lord. The law is settled, my lord, now. The law is settled. What it says, even in Jagdish's case, my lord, it does not matter, my lord. My reply
says it has to come through regular appointment.
My lord, I will just place the law, my lord. I'll just place the law in that aspect, my lord. Where is it? My lord, before that, my lord, may just I have also prepared my notes of arguments.
Because see, you're saying that it has not been refuted, this averment between para 5.
Yes,
so being unrefuted amounts to admission.
Yes.
Correct. But then para 5 is one, in another paragraph you've written something else.
My lord, then
so the answer to the other paragraph, will it mean that then it'll be in contradiction?
My lord, we'll have to co-jointly read. What I mean to say, my lord, is we are casual workers, my lord, and over the period of time, we have attained the status of a long-standing casual workers, and initially we have been appointed in a sanction post, my lord. There is a post which is a sanction post. It's a vacant like. We were being inducted into this process as a casual workers, and we continue to work. Some of them continue to work for 15 years, 20 years. Some retired also, my lord. So therefore, now, my lord, when the principle of equal pay of equal work, when it comes to, my lord, it does not matter. You work for 1 month, you work for 10 days, you work for 10 years, doesn't matter, my lord. Or whether it is a casual work, or it is a contractual work, or it is an ad hoc, it doesn't matter. Whether you are qualified, whether you are not qualified, the mode of recruitment doesn't matter. Jagdish has set up that law, my lord. It says that once you are appointed, and if you are doing a similar kind of job, my lord, then you are at least entitled to the basic law. Therefore, my lord, whatever pleadings the appellants have had, it's all devoid of merit, and it's not a law, my lord. It's not a law. What his lordship, Justice Dingdo, has gone, that is a correct proposition of law, my lord. That's a correct. And today, my lord, they are saying that two posts, equation of two posts. We are not asking for equation of two posts. Whatever judgments that have been placed before, my lord, Mota Singh to Chaurasia and to Haryana's case, my lord, these are all of two posts, where they are saying that we work, the nature of work, even the nomenclature may not be same, but we are performing the same job, and therefore please equate the post. They're saying that no, the equation of post and technicalities of fixing the salary, it's a technical matter. The court will not do that. That's the law. But here what we're saying, simply we're saying, if the Mali, there is a post in a Mali as a regular appointed.
So where have you shown the nature of duties? So because appointment shown part-time one, so nature of duties have to be exactly similar.
Nature of duty have to be exactly similar, my lord.
In the hours that you paragraph, your terms of engagement, what can your...
My lord, once, then again I'll have to come back to satisfy my lord to paragraph 5, my lord. Can you come back to paragraph? I said in the table, my lord, name of the post. Name of the post held by the members of the union is Mali. Name of the post in regular cadre is Mali. Nature of work is maintaining and look after office garden. Did they counter to this? They didn't counter to this. So how did they today? They say that no, you have to go and prove beyond. Once you admit something, coming back again and saying that no, you have to prove. They are stopped from even raising these questions. So everything boils down to this, my lord. Everything boils down to this.
Their basic contention is?
So my basic contention is, my lord, we have been appointed in a sanction post, and we have been working for a number of years, my lord. Therefore, my lord, by operation of Judge Singh's case, my lord, we should be given at least the minimum pay scale, my lord. This is what His Lordship Justice Dingdo has correctly laid the law, my lord, based on Judge Singh's case, my lord. Now, my lord, I'll just
without ticking all the boxes,
my lord.
See, the thing is that to apply, you have to tick all the boxes. You have to come within. You have to tick. You understand what I mean? Ticking all the boxes. The terms of employment, the terms of engagement. All those things. Those boxes have to be ticked before that benefit can be given to you. Now, show that you have ticked all the boxes in the terms of appointment. Only you're saying a very blanket submission. That you're appointing a sanction post, you're got it for a long period of time, it is charging similar duties to the other people in regular appointments, and so you're entitled to the minimum pay scale given to regular employees. Correct?
My lord, yes, exactly, my lord. My lord, now, to answer to that again, what does a sweeper does, my lord? What does a sweeper does? What does a sweeper in a casual or a regular they does, my lord?
What is a part-time sweeper and a full-time sweeper? You tell us.
My lord, in the contract agreement that I'll show, my lord, my lord, here by saying that part-time does not work, my lord. Here, my lord, we report early in the morning, my lord. We leave by the office time, my lord.
See, part-time sweeper does the same type of job.
Yes.
But a part-time sweeper and a full-time sweeper, two different aspects altogether.
My lord, we have stated.
There are cases from this court itself, from this bench.
My lord.
Distinction between part-time sweeper and full-time sweeper. Same thing. It's similar to your case. Part-time sweeper, full-time sweeper. You see, we do the same thing.
My lord, then for that matter, my lord, then I'll have to show page. My lord, then for that, to answer to that, my lord, I'll have to show page. Page 351, my lord. This one. My lord,
yes.
I'll just come back to that judgment of page 44.3, my lord. 44.3 of the judge's judgment, my lord. This
from the note.
Not from the note, my lord. In the memo of appeal would be page. It's paragraph 44.3. 44.3.
That is at page 499.
No, the judgment just. Oh yeah.
Yes.
My lord. So my lord has got 44.3. 44.3.
That's page 496.
Yes, my lord.
Bhagwanda's case.
In Bhagwanda's case, my lord, I'll just read, my lord. So, in Bhagwanda's case, this court recorded that in a claim for equal wages, the duration for which an employee would remain or had remained engaged would not make any difference. So also, the manner of selection and appointment would make no difference, and therefore, whether the selection was based on the basis of open competition or was limited to a cluster of villages was considered inconsequential insofar as the applicability of the principle is concerned. And likewise, whether the appointment was for a fixed period limited 6 months or 1 year or for an unlimited duration was also considered inconsequential insofar as the applicability of the principle of equal pay for equal work is concerned. So this answers to my lord's query. It doesn't matter how I come. And it is also an admitted fact. Now, page 351 will speak for itself, my lord. Page 51.
Yes.
Page 51 of the memo of appeal will speak for itself, my lord, now.
Yes.
This is a contract agreement. Page 351.
51.
Yes, my lord. Page 351.
The standard.
This is a standard, my lord. I just gave one example.
51 is a office memorandum.
350, 351. Internal page will be
351.
351 is an agreement, a contract agreement, my lord.
No, I meant it. 51. Yes.
My lord, can you look at this, my lord? Contract agreement. This agreement made on so and so between one lady, so and so, of the first party and the chief engineer, so and so. Whereas the chief engineers, so and so, has agreed to serve the first party, and the party first has agreed to serve in MECL on the terms and conditions herein after content. These presents are there. The first party shall submit himself also to the orders of the MECL and the officers and authorities under whom she shall work from time to time to be placed by the MECL authority and shall remain in service for 1 year commencing from 31st August and subject to automatic annual renewal of contract unless there is a negative assessment on the performance of the contract workers, which shall be based on the management of report and so, so notice 1 year. So, my lord, this speaks for itself. 1 year.
Yes.
So, my lord, now, my lord, after showing that paragraph, I'll come back to Jagdish Singh's case reference again, my lord, paragraph 56, my lord, of the Jagdish Singh's case, my lord. Before I pass on my notes of argument, my lord. Paragraph 56, my lord, may I just read, my lord? May?
Of course.
Paragraph
Please.
56.
56.
Paragraph 56 of Jagdish Singh's case, my lord. Ah, 56, my lord has got
500 and
508.
508.
okay.
My lord, 56, may I just read, my lord?
One line 56.
No, 56, 57 onwards, my lord. 56, 57 onwards, my lord. 57. Oh, yeah. I'll read 57. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized by us in paragraph 42 herein above. The principle of equal pay for equal work has also been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, contractual, and the like. The legal position relating to temporary employees has been summarized by us in para 44 herein above. The above legal position which has been repeated declared. So therefore, my lord, nomenclature now. Work charge, contractual, casual, does not make a difference. If you are working, which they have admitted, my lord, then you are by law entitled to the minimum pay scale. This is what his lordship just said. What is wrong with that? His lordship has said, my lord,
yes.
my lord, now let us have a look at his lordship's judgment, my lord, the impugned judgment, my lord. My lord, paragraph 2 of his lordship's judgment is my submissions, my lord, wherein we said that we are appointed on a sanctioned post on various posts, my lord. Paragraph 3, we have said that we are discharging the same duties, my lord, as of this one. Paragraph 4, my lord, of this, my lord has got. Paragraph 4, my lord, this is where I've demonstrated how there is a disparity in the pay, my lord. Paragraph, my lord has got, that's page 33. That's how disparity, there's a pay disparity, my lord, I said. Paragraph 5, my lord, this is where I say that even the service rules applicable to the regular are also applicable to us, made to applicable to us also, my lord. And paragraph 6 is I have submitted that we also made a demand, my lord, charter of demands, my lord.
Yes.
And paragraph 7, my lord, this is we have also pointed out that, but this is not very relevant because these people were appointed in lieu of giving their land, my lord. So, and then I have referred to the citations of the judges, my lord. And thereafter, in par contra, my lord, from paragraph 10 onwards, my lord, this is the objections raised by the respondents, that appellant here, my lord. They say that there is a different course of action. First point, that they cannot club a course of action. This is first point they raise. And they say that, again, paragraph 5, again, they say that while admitting also, they say that you cannot club all these course of action, my lord. All along, they have been saying that you cannot close course of action, my lord. Then, my lord, paragraph, they have referred to some judgments, which my learned senior has reiterated in here also. Now comes in, now paragraph 17, my lord. Paragraph 17, from here it will be relevant, my lord. Upon, my lord, 17, my lord, now I'll read, my lord, from here. Upon hearing the argument advanced by the respective learned counsel for the parties and on perusal of the pleadings on record, this court is made to understand that the dispute is essentially centered on the allegation of the petitioner union that its members are being discriminated as far as the just dues are concerned, particularly in the area of equal pay for equal work. There is no dispute by the respondent authorities with regard to the status of the petitioner, my lord. There is no dispute to the status, my lord. In fact, the respondents would assert that the said members of the petitioner are contractual employees of the MECL appointed on a need basis for a period of 1 year, fixed with pay scale in line with Minimum Wages Act and with certain additional financial facilities as may be elaborated at paragraph 13. They have also agreed we are contractual. They even well fortified our case by saying that no, you are not only a casual, you are a contractual. Why are you saying casual? This is what their words are. Okay, yes. Now, 19. The respondents MECL would, however, contend that a claim for equal pay for equal work would exist only when there is a wholesale identity between the holders of two posts, as was in the case of Steel Authority of India, so and so, and further that even if the designation of the job is same, difference in educational or technical educations, as was observed in the case of Haryana versus Jasmeer Singh, reported in so and so, had also to be taken into account. Reliance was also placed in the case of Indian Navy civilian, so and so, so and so, so and so more. Now, 20. The said respondent has further emphasized the point that equation of posts and determination of pay scales in the primary function of the executive and not for the judiciary. Such function require consideration for a post of factors such as qualifications and the method of recruitment and the nature of the duties, and courts would generally not enter into the task of job evaluation, which is generally left to the expert bodies like the pay commission, etc. These propositions are present in the case of Delhi Transport Corporation Security Staff Union versus so and so, as well as in the case of R.D. Sharma, relied upon by the respondent MECL to bring home the point that this instant petition has been preferred in a case where no writ is maintainable and no fundamental or legal rights of the members of the petitioner have to be violated. On consideration of the proposition propounded by MECL as above, where stress is laid on the aspect of equation of posts and determination of pay scales, therefore, which requires proper classification best left to be done by an expert body or committee. This court is made aware that the case of the petitioner union is not for equation of the post or determination of pay scale connected thereto, but that there already exists same category of posts, for example, the post of cleaner or mali, some manned by employees who have been recruited through regular process and some by employees appointed on contractual basis for a period of 1 year. The same being renewed from time to time, what is evident is that there are two classes of employees, one regular, another temporary, performing the same nature of work by the same designation and drawing two different sets of pay scales as evident from the chart drawn up by the petitioner at para 6 of the petition. These authorities cited by MECL are therefore not relevant in the case at hand, my lord. So whatever authority, so 1 minute. Oh, my lord, my lord. Oh.
Two different sets of pay scales. We say there is an asking for pay scale, it will say two different pay scales. So they are asking for the same pay scale and where
Yes.
So coming to the point of the course of action at paragraph 22, what is his lordship held, my lord? It said 22. The respondent MECL has also further contended that this petition filed in a representative capacity is not maintainable inasmuch as it is evident that the members of the petitioner union have separate causes of action, with each members having a distinct cause of action against the action of the respondent. Again, in matters of demand of equal pay for equal work, it is required to demonstrate the source of entry, the qualification possessed, and the manner of recruitment, etc. of each individual as against their counterparts holding the same post who are regular. The case of Binod Kumar Supra and of P. Radhakrishna Naidu Supra, as well of that Mr. Muta Singh Supra, was relied upon by the respondent. Now, my lord, 23. The reliance of respondent MECL on the basis on the case of Binod Kumar Supra, P. Radhakrishna Naidu and Muta Singh, wherein it is noticed that in each of these cases, a joint petition was filed by several petitioners seeking common relief, but pursuing their individual interest, and therefore such petitioners were called upon to pursue their respective individual cases, or even if allowed to join together, to pay the required court fees as individuals, cannot be equated with the case in hand, as it is the case a recognized registered union has taken up the common cause of all its members as regard to the demand of equal pay for equal work. Therefore, the objection of the respondent MECL as regard the maintainability of this petition on the ground that it would not have been filed by the petitioner union on behalf of its members collectively as separate causes of action exists pertaining to individual claims against respective force occupied by the said members cannot be accepted by this court, inasmuch as the petitioner through General Secretary duly authorized by the resolution annexed as Annexure A3 is representing its member who are all contractual employees of the respondent MECL. They have all common cause, that is a demand for grant of equal pay for equal work. The basis of the grievance of the members of the petitioner is alleged unequal treatment to them in a manner of service vis-a-vis the counterparts in the same organization who are regular employees. On this score, this court is of the opinion that this petition is maintainable, and my lord, his lordship went on to refer to the judgments, my lord, to justify, my lord. So therefore, my lord, this judgment, my lord, suffers no infirmity, my lord, as per law, my lord. And my lord, I have just passed on my notes of argument to substantiate whatever I have spent and to counter, my lord. So, my lord, in view of this, my lord, and I have dealt in this.
You mentioned citations.
Yes,
only Jagjit Singh only.
No. I have cited Workman of Dharampal. I'm just passing Workman of Dharampal's case also, my lord. In this, because just to say, because there was an objection that joining of clauses, cause of actions, yes, because a judicial union can represent. This is the judgment, my lord. In my notes, I've referred relevant paragraphs also, my lord, for my lord's assistance. But I'll not take my lord's time in reading all those paragraphs now, my lord. And
65.
I'm sorry, my lord.
I mean, the
65, bench. My lord. It's a very old judgment, my lord.
Yes.
So I will not bother my lord by reading the paragraphs, my lord. I've passed on the citations, yes, also, my lord. And on the first point, I've tried to tackle on the maintainability of the writ petition, my lord.
Just now. Yes.
And on the second point, my lord, I try to tackle the equal pay for the equal work, my lord. And also in the third point, my lord, I try to tackle the executive domain argument is misplaced, because they're saying that no, it is an executive work of pay, court has no business to do.
Expert body.
Yes, expert body, I've tackled that also, my lord. And non-regularization argument, because they were asking for regularization. Some citations are there, which they have placed today also, my lord, large seniors have placed. Those are regarding regularization.
The same judgments with single bench have been again reiterated today, I think.
My lord. Yes. So, regularization is misplaced, my lord, because we are not asking for regularization, my lord. Therefore, my lord, my prayer would be, my lord, devoid of merit, this writ petition, this writ appeal deserves to be dismissed, my lord. That is all, my lord.
Then we'll reserve a judgment.
Yes, my lord. Only one 371 we have denied. In my friend has said that there is an admission in the counter affidavit. Is not correct, my lord. 371 I have denied it. 371 is part of the affidavit in opposition, counter affidavit at page 371, paragraph C1, my lord. 371, my lord, the petitioner's association has failed to disclose the fact contractual employees are appointed on need basis and are appointed on period on the basis 371 bottom, my lord.
Oh.
My lord, that's it.
That is all.
Obliged.
The hearing concluded, judgment reserved.
Yes.
Ten minutes will sit.
Any mention?
Please, Lordship, I beg to mention item number 30, Lordship.
Number?
Number 30.
No objection.
2 weeks.
After it matter.
Service.
2 weeks, yes. Yes, yes.
Please, Lordship. Lordship, I beg to mention item number 16. 16. Lordship, I'm praying for some accommodation in this matter. Arguing counsel is having some personal difficulty to take up the matter.
Lordship, this is that.
Counsel.
She has general.
Lordship, this is that reconstitution matter, Lordship.
Walk off.
Section 14.
You asked your other petitioner very interested in carrying on the case.
We are interested, Lordship. Interested, Lordship.
Okay, 2 weeks, yeah. 2 weeks or 1 week?
2 weeks.
Yes.
Highly obliged.
Please, Lordship. I'd like to mention item number 28, Lordship.
Where's MS Tiangi? Where is she? You've taken consent?
From the private respondent, Lordship. It's just for executing of the agreement, Lordship, for payment of the loan. It's 2 weeks' time will be given, Lordship.
2 weeks' time. Who's the other side? You informed him or not?
Yes, Lordship. Mr. Karmapla.
Okay.
Obliged, Lordship.
Yes, Mr. Parian.
Please, Lordship. Lordship, I beg to mention item number 19, Lordship. I pray for 2 weeks' time, Lordship, since senior counsel is indisposed, Lordship.
And for the petitioner, Lordship.
Yeah, objection.
Objection.
Let
it be 1 week. Let it be 1 week.
Urgency?
Some urgency is there. 1 week is always.
1 week, okay. Otherwise, you argue the matter.
Lordship.
Yes.
Highly obliged.
May please, Lordship, I beg to mention item 23. Lordship, I pray for 2 weeks' time, Lordship.
This is regarding petition, Your Lordship. Yesterday, similar matter has been passed because
why you are paying for whom?
For Ms. Arkashian, Your Lordship.
No, not for which respondent?
For the respondent number 7.
Private respondent.
Private respondent. So first wife, Your Lordship.
You are the second wife.
No, I'm the pensioner, Your Lordship. Employee.
Why are you blocking his pension?
Your Lordship, he is my husband, Your Lordship.
So you have right to block his pension just because he's your husband?
No, Your Lordship, he has a second wife, Your Lordship, without divorcing me, Your Lordship. That's why I'm trying to stop the nominee, Your Lordship, from changing the nominee.
The state is...
Okay, 1 week, yes.
My objection may be recorded, Your Lordship.
Objection for adjournment?
Maybe because...
we'll not record it, let us come to 1 week, yes.
Lordship. Much blessed, Lordship.
May I place, Your Lordship? I beg to mention item number 24.
For the petitioner or for the respondent? Yes.
For the respondent.
No objection.
Mr. Devnath on leave?
Yes, on leave.
2 weeks, yes. Yes.
Supplementary list, item number 1.
May it please, Lordship. Lordship, here the petitioner's predecessor had been the owner.
Who's the owner?
The petitioner's predecessor in interest, Lordship, had been the owner of a plot of land measuring around 50 lassa, Lordship. 50. Now in the year 2009, Lordship, that some portion of the land was gifted to the Hawakhana Durga Puja Committee, Lordship. Out of 50 lassa, 35 lassa was gifted to the Puja Committee,
by you?
Lordship. Yeah, by the ancestor, Lordship, by the predecessor of the petitioners, Lordship. Then the remaining 15 lassa, Lordship, was written with the petitioners, Lordship. Then my Lord will find the gift deed, Lordship. Then based on the gift deed, Lordship, the property was mutated in the name of the Puja Committee, Lordship. That is 35.
At page 35?
30. My Lord gift deed will find at page 27, Lordship. That is the type copy, Lordship.
Okay, yes.
Then, Lordship, subsequently, my Lord will find that page 33 is the patta issued to the Puja Committee, Lordship. Then there are two Patta Lordship, one issued to the Puja Committee, and the remaining partial Lordship was mutated in the name of the Petitioner Lordship.
Petitioner's interest or petitioner?
Petitioner's mother Lordship. Here, the petitioner has filed the writ petition on the strength of power of attorney Lordship.
Yes.
Now that is the page 33 is the Patta issued to the committee Lordship.
Yes.
And my Lord will find the page 41.
What do you want now?
Now, Lordship, there is a discrepancy with regard to the boundary Lordship. So, I put up an application before the District Council Lordship for demarcation.
You have not done anything?
Not done, Lordship. That
When did you put up the application?
my Lord will find that the application was on 6 May 2024, Lordship.
That's not just not even 2 months ago.
No, my Lord, 2024, Lordship.
Or 24?
Yes, Lordship. Last year, Lordship.
Yes, Mr. D.
My lord, the deputy CEM has forwarded this letter to ASO. My lord, I'll just take instruction. Let it come up Monday.
My Lord, it can be disposed of.
No, let's come
Or
Monday.
we'll take a call.
My Lord.
Let it come on Tuesday.
Tuesday.
Yes, sir, Mr. SRS and Council Petitioner, you should notice Ms. SD is present behalf of the respondents 1 to 4. No further notice required on the respondents. Notice not to be issued to 1, 5 and 6 at present. Mr. S.A. Sheikh submits that the matter is limited only to the prayer for demarcation made before the respondent 1 to 4 since over a year, which has not been addressed. Next paragraph, Ms. SD to obtain instructions based on Tuesday.
Item number 2.
Tuesday on 3. Yes.
My lord, this is on a very limited point, my lord. This appeal has been filed.
Yes.
Here the only 2 points which arises whether a court under 1940 Act, while hearing a petition under 14 and 17 for making an award rule of the court, and along with the 3033 petition for setting aside, whether the court can touch the award. Either court has to set aside the award, or the court has to make it rule of the court. Now here the Honorable Trial Court, what has done, court has said ki I don't find anything to interfere with the award, makes the award rule of the court, but then goes one step ahead to clarify the award, which is not permitted. Court cannot clarify what the arbitrator has awarded. If court thinks that the award is wrong in any manner, either court has to set aside the award or make it rule of the court. The impugned order is at page 71, my lord.
Yes.
Annexure 7, page starts from 71. The operating portion is at page 80. This is in an application under section 14 and 17 for making the award rule of the court. Now the court below at page 80, my lord.
Yes.
The petitioner's case is decreed as follows. The instant case is decreed on contest and the award dated 5/9/2003 passed by the sole arbitrator in contact agreement number such and such is made rule of the court.
So the first appeal is on?
Yes.
Okay.
However, it is clarified that the post-award interest, it is clarified.
Yes.
The post-award interest of 15% per annum shall be calculated on the awarded amount and not on the total payable amount.
What did the arbitrator say?
The arbitrator has given that post-award interest at the rate of 15% on the total payable amount. And trial court has gone one step ahead without jurisdiction to clarify and saying that it will not be on the total payable,
Only the awarded amount.
which is not awarded amount. No,
That is clarified only on awarded amount.
Awarded amount.
Yes. Okay, yes, Dr. Mozika, you take notice.
So this is one thing.
Yeah.
And even if, while disposing the 3033 petition, you are at last page 147. In view of last page here, This is the order passed under Section 3033. In view of what has been discussed above, this court finds no reason to interfere with the findings of the learned arbitrator. And the award dated 5/9/2003 passed by the sole arbitrator is hereby upheld, except that the post-award interest shall be calculated on the awarded amount, which is not at all permitted by a court hearing a petition under 3033, my lord.
But if I would take lordship to page 39, my lord.
39.
39. This is the award, man.
The award. Yes.
Well, claim number 7 and 8, lordship.
Yes.
Now, what arbitrator said, my lord, after considering arguments of both the parties, I found that the claimant signed the final bill on so and so, and arbitration was invoked on so and so. The claimant should have been paid all the dues within 6 months of signing of the final bill, and arbitration was invoked on 5/3/94. Therefore, the claim is due from 5/10/94. Therefore, I award simple interest on the total awarded amount under so and so at the rate of 10% per annum from so and so. So, this is pre-reference period, my lord, 12%. For pendente light what arbitrators are, I further allow Union of India a period of 90 days from the date of signing of the award to pay the amount to the contractor, so and so, in terms of the award, and failure to do so, the Union of India is directed to pay further simple interest 15% per annum on the total payable amount in terms of the award from the date of signing the award, date of release of the
Then we'll hear it. That is conditional, according to you.
My lord, I placed the Supreme Court decision, but under the old act, my lord, there was no provision of compounding.
Okay,
Not compound interest, my lord. Under the old Act 1940, there was no provision for interest.
Should the record necessary?
My lord?
It is on record, my lord. It's only a question of law.
Records may be called for?
May be called.
Yes, my lord.
Yes, I heard Ms. PDP Barua, learned counsel for the appellant. Issue notice, Dr. Muzika is present with so-and-so, accepts so note for the... What about the, you want to make the arbitrator a part, you should
Not
notice.
required. It's only a formal party notice.
This is on behalf of 1, 2, 3. No notice to issue to the former respondent at this stage. Stuff. Upon hearing the learned counsel for the appellant, call for the records from the court of so and so, just after receipt of records for admission hearing. We'll dispose of admission hearing stage. It's only a point of law.
Only a point of law.
Yes.
Obliged.
Item number 3.
Lordship, the learned Advocate General is on legs. Can you take it at the end of the board?
If my lords have this matter on Monday.
Lordship, at the end of the board.
Won't be there, Mr. Paul.
Tuesday, my lords.
At the end of the board, Lordship.
Let him come first. Let's see. Well, take a chance.
I'm prepared with the matter, my lords, but I was awaiting some instructions in this matter. This is that review, the matter that came up before my lords the other day.
Review and appeal.
If it's not inconvenient.
Review and appeal.
My lords. Tuesday, my lords, if it's not inconvenient.
At the end of the board, Lordship.
End of the board.
Yes, Lordship.
What's your objective? We'll let them come.
My lords.
What's your point?
Daily list item number 1.
Lordship, I pray some time, Lordship. Just a week. I pray for 1 week's time.
Yeah, the pleadings are complete.
No, Lordship, just to file rejoinder, Lordship.
How long you do you need?
Just 1 week, Lordship.
Yes, Mr. You have placed for a lot further 1 week's time to file rejoinder affidavit. Yes.
Item number 2.
In pursuance of the order, my lord, passed in the miss case, my lord, this has to proceed for the cross-examination, my lord.
Sure. Order passed miss case?
Yes, my lord. That order which was passed, my lord, in the miss case.
Oh yeah, that was.
I am appearing the respondent.
Yes. So when are you ready with the witnesses?
We have already submitted our depositions, my lord. Now they need to cross, my lord.
Yes. When's the date?
August.
First week of August, Your Lordships.
Last week of August will be too late, my lord. Let it be this month, in the end of the month.
Your Lordships, the reason why I am seeking for this date because I need to be physically available in Shillong, Your Lordships. So first week of August would be.
Can't even see you. Even you're not visually available now.
Yes. No, Your Lordship, my video is on. There must be some technical glitch.
Yes. Yes, Mr. Pala.
Let it be
August, Your Lordship.
Let it be.
You take a date. The court master will fix. Yes.
28th of
Matter
July,
for-
my lord.
how many witnesses?
28th of July.
This is matter for examination of cross-examination.
Cross-examination of the witness.
Your Lordships, in that case, 1st of August would be fine. July would not be preferable, Your Lordships.
For 1 month, my lord. It is an election petition, my lord. There is an urgency in this matter.
Yes, you will have not crossed the threshold also now. The elections are coming again soon. Yes.
I'm deeply obliged, Your Lordships.
Yes. Yes, Mr. Person.
Affidavit of service has been filed, Your Lordship.
Yes?
Affidavit of service on behalf of the respondent number 8.
Who is appearing for the state? Nobody. Number 7 served. 6 and 7.
You've taken steps just on the respondent number 8, Your Lordship.
What about 6 and 7?
6 and 7. We've already filed previously, Your Lordship, for 6 and 7.
Affidavit.
Yes, Your Lordship.
Now that means ED card was received also. Ombudsman indicates that ED card was received for number 8. Mr. Pasanthi also submits that affidavit indicating service being filed. According service complete all respondents. What do you want now? But none appears for the current respondents.
Your Lordship, state
Affidavit
already
filed.
filed, yes.
Yes. This after 2 weeks for appearance of the respondents and for further orders. Yes.
Item number 4.
My lord, it is his petition. Lordship may have a look at, my lord, 17.6 order. This is the last order.
Yeah.
So that day I appeared through video conferencing.
Has she allowed to operate her account?
Well, as the accounts have been finally been unfrozen.
We have allowed. Now the issues for adjudication before your lordships will be whether the bank anyway collided with or whether the bank was at fault in the transaction, which is online transaction, GPay transaction, or whether the bank, while allowing the transaction, then subsequently could have stopped the payment, which was already deposited in some other bank, SBI. We don't have control over that. We cannot ask them to stop, my lord. And whether it was because of the sheer negligence of the customer, namely the writ petitioner. These are the issues. These are the issues. On that, it will be dependent whether the bank is liable to, she is liable to recover the amount from the bank after transferring that on her own volition, my lord, maybe under some reasons, my lord, who telephoned whom. The bank is not concerned. When one pushes the right button giving the PIN, PIN, my lord, GPay, it is only personal to her. She is not supposed to share it with anybody else, nor she is supposed to act on a fictitious call, my lord. That
was GPay?
GPay. So that was done and that was finished. Now, bank doesn't want that one should be defrauded by, one should be frauded on by anybody else, my lord. There are a lot of cyber crimes. No bank wants it. Therefore, in this case, police was also called upon by your lordship to investigate. And my lord, I must say that it was very lethargic. Police took 3 days to register the case on the filing of the FIR, and there are a lot of things. Now, if your lordship wants to hear the matter and dispose it of, I am ready. It is his petition. If your lordship wants to hear it some other day, these will be issues. I will show.
All the pleadings are complete?
Pleadings are complete.
We will have a hearing because the only thing today is whether you, because the only prayer they want is the account was frozen.
So that may be fixed, my lord. Only thing, since I come from a not very far away place, only 1 or 2 days adjustment, my lord. And
Yes,
that day I had to appear through video recording. I don't know whether
we give you the liberty.
But it seems
Mr.
that it
E.C.
is not.
Barbara, the Senior Counsel, has submitted at the bar that the account of the petition has since been defreezed, and she is operating the same. The same concurred to Mr. K. Paul and Senior Counsel for the petitioner. Stop as the matter is ripe, next paragraph ripe for hearing.
It may come for admission hearing, my lord.
Okay,
At the stage of admission, can we dispose?
It can be disposed of, my lord. Endeavors shall be
hearings
made.
are complete, and there's some urgency. This is a matter of admission hearing on.
Well, just
You take a
one
date.
prayer I'd have is that since my lords are fixing a date for hearing of this matter, the state may be directed to provide a status report on what is the actual stage of investigation?
Yes, for the state.
That's for the police, yes.
That would be important.
Yes. Yes, authorization hearing also. On the set date, have you have fresh status report?
Sometime, my lord. Last time we had filed on the 6th.
Then we'll have to have another date before the hearing. Mr. Borbora, we'll have to have.
Lordship may give a time limit to the police.
My lords may fix a date for hearing, my lords, and 3 days prior to that they can serve a copy of the report on both the sides, so that the matter cannot burden your lordship.
That is reasonable. Stop. It is further directed that the state respondent shall furnish the latest status report 3 days before the set date.
That will, my lord, they will take, my lord. I like to appear personally, my lord.
Of course, it's a pleasure.
It's a pleasure.
I have just now seen that is not visible. I hope my voice doesn't appear to be a ghost voice. Obliged.
Item number 5.
Please, Lordships. Lordship, I pray this matter may be passed over for the end of the board. Lordship, the learned Advocate General will be appearing in this matter. Lordship, he wants to.
Who will be appearing?
Learned Advocate General, Lordship.
Your Lordship, on the last order, we were
Now entering appearance today, first time.
Yes, Lordship.
Then?
We were given notice, Lordship. The Advocate General will be appearing in this matter. Lordship, he'll be giving some. He wants to give some submissions, Lordship, in this matter.
What submissions he wants to give?
Lordship,
He didn't divulge them to you.
No, Lordship. Like yesterday, I was some difficulty, Lordship.
What does the order say violated? Is it division bench order?
Division bench order, yeah.
The matter is before the Supreme Court.
Lordship.
It's come back.
It's come back.
Lordship, if this matter be taken up at the end of the board, Lordship, we can.
Take another day when
let it come after. Yes.
Mr. Chidaranand present today.
May have it at the end of the board, Lordship.
Your Lordship, my senior is on legs on division bench, so.
Lordship, I think
it's a last item, so we don't know how long it will take. Let it come on after 1 week.
On Tuesday. AG will be here, yes. Mr. H. Chidaranand has entered appearance today on behalf of the respondents and submits that he is led by the Advocate General the matter. And he prays that the matter is on Tuesday.
Lordship.
Yes.
Item number 6.
Yes.
May it please your Lordship. Lordship, the matter has become infractious, Lordship, as the respondent has complied with the judgment and order dated 24 June.
So as it's stated that the order has been complied with, nothing is left for consideration, the contempt is closed. Disposed of.
Item 7.
Lordship, I pray for 2 weeks' time to file a short rejoinder, Lordship. Here that the FEDCO has filed an affidavit saying that.
No, now, Mr. Marak, last time we already asked.
Yes, Lordship.
Since 12 June.
I'll file a small affidavit, Lordship. Short.
No, he already given time. Further time required.
Yes, further time.
How much? 1 week?
2 weeks, Lordship.
2 weeks further time is prayed allowed for rejoinder.
7, 8, and 12.
It's correct.
Item number 7, 8, and
12.
Connected.
Item number 9.
There's a petitioner. Well, we are challenging the maintainability of these writ petitions before my lords.
Who is the petitioner?
I think Mr. Sinkon is there.
Mr. Momin.
Sinkon, sir. Mr. N.
Oh,
Sinkon.
Sinkon, where is he?
Yes. The challenge to is, my lords, a selection process where these petitioners have participated. Laws
should
were.
have arithmetic or something like that.
I'm sorry, my lord.
You should have.
Lordships. Terms of the advertisement where they have participated, my lords, and not succeeded. Now those terms are sought to be challenged before my lords. Laws well settled.
No, we have not passed interim orders. Where's Mr. Sinkon?
He's here.
Yes, you received affidavit. It was filed by you, Mr. Paul.
My lords.
My lord, I have just received the affidavit, my lord. I am yet to go through, my lord.
After 1 week?
1 week, my lord.
Yes, after since been filed for number 3, Mrs. Ensincon. As after just been filed as number 3, Mrs. Ensincon praised that matter for 1 week. Yes. For the joint if necessary.
Well.
And also,
All right.
Then. Same.
Yes, after 1 week.
Item number 10.
We have someone.
I'll be appearing on behalf of respondent number 2, 3, and 4 in this matter, Millet.
Yes, Mr. Chanda already entered appearance last time.
We'll file a response.
Will you file?
Mr. Kirpal prays for allowed further. The council for 2, 3, and 4 prays allowed further. 2 weeks time.
2 weeks time.
What about state?
They said they will not file yet.
Yes.
Obliged. Must be less lordship.
Yes, on phone.
No, the sheet not updated.
11.
May it please your lordship. Your lordship, I'm praying for 2 weeks' time for filing the rejoinder.
Second time before?
First time, your lordship.
This is the second time.
Yeah, we are not
Second time.
Or the third time?
No, your lordship.
No, okay.
This is the second time.
Yeah. Ms. Ibla prays for further.
2 weeks'
2 weeks time for rejoinder. Just after 2 weeks, yes.
And oblige your lordship.
12. Sorry, 13.
Your Lordship, I'm appearing on behalf of Lieutenant Counsel Mr. Estep, and he is presently held up in court number 4.
Yes, you paid them all. What was your submission last time?
Lordship-
You cut some TDS, no?
Not the TDS, Lordship. In some of the order sheets, the name of the counsel was not appearing, so he had not appeared in the matter. So on that context, the deductions were made.
We close the matter otherwise?
Yes, Lordship.
Where's Mr. Deb?
He's held up in court number 4, Lordship.
Is that code number 4?
Can you kindly take up this matter, Lead?
And the second half? After some time, yes.
Obliged,
You've cleared
Lordship.
amounts which you feel you've paid.
Yes, Lordship. The entitled amount has already been paid.
Yes. For the amount he claimed, he can file money suit.
Yes, Lordship.
Okay.
14.
May it please your lordship. Your lordship, we're waiting for the status report.
Yes, Mr. Nupur, what instructions?
Lordship, in fact, this matter has to be decided by the EC, Lordship. There's an order from this court as well. Page 141, Your Lordship.
Officer indicates that service has been completed on respondent number 9, whereas respondent 10 is yet to be served. Any urgency?
No, your lordship.
Just after 2 weeks for service report number 10.
Lordship.
Petitioner is at liberty to obtain status. Yes.
Lordship, in fact, the matter can be relooked by the EC, perhaps.
Let Mr.
There's an
Sen
order.
be there.
Lordship.
He's not here.
15.
My lord, I am entering appearance on behalf of respondent number 1 and 2, my lord.
1 and 2 and
For respondent number 3.
My lord, here we have one objection, my lord, in the court title itself. Now, Nongsdeng does not have an ilaka, my lord.
1 and 2. So
1 and 2, my lord. The Sordar and the executive committee, my lord.
and you are for Sora. Yes.
So, my lord, here, my lord, I don't know whether it is deliberately, intentionally is done, because we don't have an ilaka, my lord. So, we have the sirdarship, my lord. So now ilaka, if you say ilaka, then ilaka will have a different connotation and meaning and jurisdiction and power altogether. So no, we don't have this. So
it doesn't matter. So that should fine. Yes.
But this, my lord, then I will file a
Nomenclature problem we have.
not only a nomenclature problem, because this entire thing is jurisdiction, the power, because subsequently they will go on to say even the challenging somewhere the power of this aim also, my lord, of the
You file affidavit.
My lord, will file.
Yes,
my lord.
Mr. P. You went under appearance on behalf of Ms. 1, and 2, Mr. Carlindo on number 3. Such notice complete or respondents. Learned counsels pray for allowed
2 weeks time, my lord.
and to file their affidavits. Just for 2 weeks, yes.
My lord. Obliged.
Obliged, my lord.
Hearing 17.
You know, if you hearings will take up at 2 o'clock to 15 years. What about the part 1 matters there, Mr. Advocate General, the review matter? How long will it take?
Yes, madam.
Let's finish all the part 1 matters first, if possible. Yes.
My lords, I had made a request. If your lordships are kindly pleased to take up this matter on Monday. My lords had indicated that this court is not available on Monday.
Tuesday, Mr. Advocate General.
Wednesday, your lordship may have it on Wednesday.
Wednesday.
On the prayer of the council of the parties, is the matter on
Wednesday. Obliged.
Yes.
Second call 13. 13.
Orders. Deb. Where's Mr. S. Deb?
He's a date here.
Where's the other council disappeared? So she's there. He's still busy. So take it after 2 weeks.
Lordship.
Yes?
No problem, Lordship.
Yes, as the arguing counsel for the petitioners are present, list after 2 weeks stop. And Dr. P. Agarwal next submitted that whatever admissible amounts have since been
Has been paid.
released to the petitioner. The same is noted. Yes, how many hearing?
Well, if the other matters.
We don't want the court don't waste time to come and sit and people adjourn. Which matters were fixed will be taken up. All 6 matters will be taken up.
My lord, may kindly fix it some other day, my lord. Today, I'll be leaving after some time. Yes,
Which matter? Number 6.
my lord, item number 21, 22,
And 17, 18.
17 and 18, my lord. Connected matters.
Connected matters, my lord.
Ask Anu after that.
Son. 5.
Hassan.
I have counted together.
21, 22.
I already counted together.
How many left?
5.
Yes, okay. The other matters are ready.
25 mentioned. You are appearing 25.
No, 25 is what?
20?
20.
Made this is the lordship.
Yes.
Lordship, so for item 20 is concerned,
Yeah,
your lordship,
objection.
there is a stay operating, your lordship.
The objection will hear it.
Stay per se, Lordship.
It is stay because there is a direction to close the advertisement, your lordship, that has been halted by
There's no stay
the
because
order
we-
passed by
We'll
this.
hear it then.
It can come on Tuesday, Lordship.
Tuesday is packed now.
Wednesday, Lordship. Subject to
When is a fixed matter?
Wednesday, Lordship.
Lordship, then Wednesday, yes, lordship, as a fixed item, if lordship is
Item number 25, lordship, I'm paying.
apply, your lordship.
This is the tender matter, lordship.
2 weeks, okay, fixed. Yeah.
Lordship, any lordship.
That's it.
26.
Other matters were ready at 2 o'clock. You ready with the matter?
Yes, my lord, 26, my lord.
Then we'll take it up at 2 o'clock.
7, 29.
Yes.
29.
2 o'clock.
Yes, Your Lordship.
Rest of the matters 2 o'clock.
26.
May I please, Your Lordship?
Was VC?
No, my lord.
Oh.
My lord. School headmaster, my lord. Government aided school, my lord. My lord, the matter herein, my lord, is with regard dispute with regard to the appointment of the headmaster of the school, my lord. The petitioner.
Right respondent here.
Yes, my lord.
Ready?
Yes, my lord.
One thing, Mr. Qureshi is for 27. He is not.
Where's the Kurushi 27?
My lord, actually, this
Both are
matter.
connected matters.
My lord,
Same
no,
school.
my lord. School same, my lord.
Where's item 27? Taking up together?
It was taken up listed.
Don't have any part, no piecemeal business.
Yes.
If it's we dispose of the entire matter.
It is connected, my lord.
Where is adjourned?
No, my lord.
Then where was the Kurushi?
My lord, no intimation, my lord.
Next item is 27.
Next item is 27. My lord, for
Now, Mr. Kurushi is espousing whose cause?
My lord, his own cause, my lord.
No,
He,
I mean not his.
yes, my lord, he is the, my lord.
Supporting you?
No, my lord. He also claiming to be the headmaster of
Then
the
there's a
school.
problem. If supporting you is fine.
My lord.
The case is, Lordship, that I have been appointed as the in-charge head teacher.
They all against you.
They are all against me. One saying
You're
that-
serving now also.
Yes, one is saying that he is more senior to me, which Mr. Hassan is saying, and
Yes.
Mr. Qureshi is saying that he is more qualified to them.
And what about you? You're not qualified or not senior.
I am saying that qualification has nothing to do because admittedly Mr. Qureshi is petitioner, is the junior most teacher in the school.
And Mr. Hassan?
And Mr. Hassan is junior to me.
No, my lord, we, with private respondent and the petitioner were appointed and joined in the same date, my lord. Joining is the same, my lord.
Appointment date is different,
My lord, joining is the same, my lord.
3
My
days.
lord,
You appointed before.
3 days earlier.
my lord,
3 days.
here the issue of appointment with regard to the headmaster lies with the, my lord, MC, my lord. MC is the best authority to decide who will lead the school, my lord.
Who's appearing for MC?
My lord, MC, managing committee, my lord. There is no managing committee actually, my lord. There is no managing committee. Managing committee was not constituted
Committee is not made party.
because there is no managing committee actually. So we couldn't make party.
Why there's no managing committee? What happened?
Because term was expired, my lord, as well as the previous headmaster, Shri Amjad Hussain, was also retired. Then parent guardian meeting was called, my lord, by the parent guardian, my lord, as per the RTE norms of my lord. Then in the said meeting on 2nd March 2024, and another meeting was held on 3rd March 2024, my lord. In that meeting, after elaborate discussion in the meeting, they decided that after perusing the records, the previous headmaster was retired and he was released. And since there was no headmaster in the school,
So why is there no MC?
My lord?
Why is there no MC?
My lord, MC term also expired, my
So
lord.
why does it not been reconstituted?
My lord, which is why the parent guardian were constituted on 2nd
What
March
happened? When was
to
the
constitute.
When did the last term expire?
Yes, my lord. My lord, kindly, my lord, have page, my lord. 31, my lord. Page 31, my lord. In my petition, my lord.
Yes.
My lord, may I read, my lord?
Yes.
Proceedings of the selected members of Noyagaon GA UP school is held today on 03/03/2024 at so and so in the premises of the school building under the selected chairperson of the MC of Noyagaon School, Shri Rafiqul Islam, and on his chair to discuss regarding for selection as senior most teacher as per Vice General Meeting Resolution number 5 and 6 and the following resolution adopted unanimously, my lord. In that meeting, my lord, the last, my lord, resolution number 1, my lord.
This is 3/3/24.
Yes, my lord.
No,
And
managing
according
committee expired when?
My lord, yes, my lord.
When did managing expire? That's what the court wants to see.
My lord, yes, my lord. My lord, managing committee expired on 2nd December 2024, my lord. At page 35 and Annexure 5, there is the resolution, my lord.
Page 35.
Page 25, my lord. This is the first meeting held on 2nd March, my lord, 2024. My lord, have, my lord. My lord, resolution number 1, my lord.
How's the school running now then?
Without MC, my lord.
How is that possible?
Because, my lord.
What's SDSU doing?
Your Lordship, only for director has appointed senior most Habibun Nihar as a
Head teacher.
head teacher, as acting in charge head teacher, Your Lordship. It is not that the permanent post is just to smooth running of the school.
No. Why is there
Because
no?
in this defined petition, because there is no whisper of Qureshi who
No. Why is there no steps taken for constituting a fresh managing committee? How does school run?
In this second read petition, Your Lordship, there is no whisper of managing committee, nothing,
Where is
only.
My lord, kindly allow me.
Kindly see page number 31
can't just
of the
proceed
read
with the
petition.
air.
Page number 31 of the read petition, my lord.
Yes.
They said this is the resolutions which was taken, my lord. This is the members of the
We're not
managing
concerned
committee.
about. I'm not concerned about his claim right now.
now
What school's concerned with? There has to be a managing committee in place. Why is no known?
It could not be considered the names which they have given, my lord. It is not as per the norms. Now, as per the norms, my lord, head in charge has been
the teachers.
Head in charge has been appointed, my lord.
That is Mr. Deb.
Yes.
If your lordship is pleased to see page 21 again, because there are some issues.
What's the issue with the school? Why they can't have a managing committee?
You kindly see page 25, the resolution. I will just point out a few issues.
Your name is Abdul Sattar.
Yes, my lord. No, her name is Habibun Nehar, my lord. My name is Abdul Sattar, my lord.
Should I kindly see the annexure 5, page 25?
Yes.
Proceeding of general meeting dated 2/3/24.
So before the managing committee expired.
Yes, no. This is before the managing committee expired.
Yes.
Now managing committee expired on December 24.
Yes.
Now thereafter, lordship will see the members who have been proposed at page 31. They are all. They are just mentioned as G member.
Mentioned as?
At page 31, the people who have been selected. Whereas, as per the requirements, lordship, the. And page
G member means. What's G member?
Governing body.
Governing member, or I don't know what.
What's the stand of the government?
Now, my lord, may kindly see page number 32.
And
32. These are the list of members, my lord, which was provided to the government. Here, my lord, first name is Sohiful Islam, second is Abdul Sukur, and third is Abdul Sattar. My lord, this is not as per the norms because.
So fine, Mr. Qureshi, I'm waiting for you, please.
So I believe the managing committee has not yet been approved by the government.
Why?
My lord, I have made specific averments in that regard. My lord,
Mr. Qureshi, you're a petitioner. Which case? You kindly take out your brief now. Are you questioning why there's no managing committee, or what is your case?
There is no managing committee at all.
Why is there no managing committee?
I don't know, the government is not following.
My lord, may kindly come to my
affidavit. Why
yes.
there's no managing committee?
Yes, my lord. We have filed, my lord, by the state. We have filed our affidavit, my lord.
Yes.
If my lord will come to page number 3 of my affidavit, my lord.
By respondent number 4.
Respondent number
4 is myself.
3, my lord. 3. Subdivisional school officer, my lord.
3.
Here, my lord. My lord, may kindly come to page paragraph 10. It says, my lord, that with regard to the averments made in paragraph 6 of the writ petition, the answering respondents state that with regard to the seniority list of teachers, the managing committee will never prepare the seniority list on the basis of length of service.
Fine, we are concerned.
Yes.
Why is no managing committee now?
No, I'm coming to that, my lord. Next paragraph, my lord, paragraph 11.
Yes.
That the answering respondents state that in connection with the post of headmaster lying vacant is due to the rivalry between the 3 assistant teachers for the same, and the public of the area is not able to take resolution on this matter. In this regard, general meeting was conducted on 3/3/2024, and they have constituted only 11 members as managing committee without the headmaster. As per the norms of the education department, there should be 12 members with the headmaster as the convener of the managing committee. However, they have shown the 12 members managing committee with their designation and specimen signature, in which petitioner was shown as senior teacher cum convener, which was supposed to be the headmaster cum convener. It has already revealed that conspiracy and manufactured committee prepared by the petitioner in his favor, which is totally false and out of norms. Hence, the respondent number 3 was not able to approve the same, and the school is without head teacher and the managing committee, my lord. Paragraph 13, my lord. It says the answering respondent state that the constitution of the managing committee by the general public in its general meeting and appointing the petitioner as headmaster and instructing him to submit the proceeding of the managing committee of Nayagaon Government Upper Primary School by letter dated so and so for approval by the respondent number 3. The general meeting has not adopted any resolution to appoint him as headmaster, and they have selected only 12 members without the headmaster keeping it pending. Hence, the respondent number 3 is not able to approve the same without headmaster of the school. As per the norms of the department, there should be 12 members in the committee, and headmaster should be the convener of the managing committee. This is the ground, my lord. How that managing committee, which has been...
Where's the order allowing the head teacher to run, allowing Mr. Dev to run the...
Page 45 of the petition.
Of Ms. Hassan's petition?
Yes, yes, the last annexure.
Yes, ma'am.
Page 45?
Page 45, annexure 9, my lord. The impugn order.
Petition?
My writ petition, my lord. Abdul Sattar, my lord. 283, my lord.
Page 45 is not here.
My lord.
Page 45?
Yes, my lord. Annexure 9, page 40. Okay. That is the impugn order, my lord.
Yes.
The impugn order, my lord.
Now the thing is that when 4th July order was passed allowing this respondent number 4
yes, my lord,
to run the school, the managing committee is still there?
No, my lord. Managing committee was pending before the respondent number 3, which is passed in...
You said that the term extended till 2/12/24. Then?
My lord, the term, my lord, sorry, my lord, that was mistaken. The term was expired in December 2023, my lord. No, my lord.
It is there
no,
in the order.
my lord, that is there, my lord. In the resolution, they have mistakenly the date was, my lord. The meeting was after expiry, my lord. The parent guardian meeting was after expiry of the the regular managing committee. Accordingly, my lord, the house parent guardian meeting in the said meeting, they empower the petitioner to...
So they all on your side?
My lord, I am not seeking for any site, my lord. I am the house, my lord, empower me to forward the managing committee resolution before the competent authority for necessary approval, and I have forwarded to the respondent number 3, my lord. Then after, when the resolution was pending before the respondent number 3 for approval, after expiry of few months, my lord, the respondent number 3 has not approved. Then I file representation before the respondent number 3 and respondent number 2 for necessary action or direction to approve the MC, my lord. The same was not done, my lord. In the middle, my lord, in the month of July, my lord, on 4th July, the impugn order was passed all of a sudden, exceeding the power, my lord, by the respondent number 2, the director, my lord.
Now, one thing, if you had been entrusted with the duty of putting up the list for approval, you didn't pursue after that, after putting it before the respondent number 3 or 2?
I pursue, my lord.
Then you didn't file a petition?
I file application, my lord.
A writ petition you file?
No, my lord. This is the writ petition I approach after.
You said that you are against the appointment of respondent number 4 only?
Yes, my lord. When
Let's see your prayer then.
Yes, my
Let's
lord.
go back, see your prayer.
Yes, my lord. Yes, my lord. At page 12, my lord.
Yes.
May I read, my lord? On the premises aforesaid, it is most humbly and respectfully prayed that your lordship may be pleased to admit this instant writ petition, call for the records, issue rule upon the respondent authorities, and upon cause or causes being shown, and upon hearing the parties, your lordship may be pleased to issue writ in the nature of mandamus or any other appropriate writ, direction or orders to quash and set aside the impugn order dated 4/7/2024, whereby the respondent number 4, Srimati so-and-so, has appointed as the in-charge headmaster by ignoring the seniority list dated so-and-so prepared by the previous MC, and further may be pleased to direct the respondent authorities to cause an inquiry by considering the seniority of teachers of the school, and further may be pleased to direct the respondent authorities to approve the newly constituted.
Okay, we'll dispose of. Yes, Mr.
Yes, my
Kulki,
lord.
what do you have to say?
The post is regarding the headmaster.
Yes.
As per the impune order, I can say that in charge of the head teacher only.
You are who? You are challenging same order.
Same order, same order.
My lord, Annexure 7 of my affidavit, my lord, may kindly have a look at it, my lord.
Only my case is that I am the higher qualifications. The qualifications will be.
Filed affidavit and I want to bring some points before your lordship.
No, of course.
Page number 41, Annexure 7, my lord.
Yes.
Here, my lord, may kindly see seniority details of teachers at Nayagaon Government UP School. This is signed by headmaster cum ex officio members. It says, in reference to the appointment detail recorded in the issue register book of so and so, the undersigned has rearranged this real number of teachers based on the order of appointment after my superannuation from service. The revised seniority details are provided below. The first is Habibul Nehar. Second is Abdul Sattar. Now this first respondent, first person is Habibul Nehar. She has been appointed as the in charge headmaster. So this is the actual seniority, my lord. Whereas the seniority which my learned,
appointment or date of joining or
which my learned,
My lord, this aspect of seniority, my lord, only the MC is the appropriate authority, my lord. Wherein the, my lord, resolution, my lord.
See, there's an absence of any MC.
My lord.
This respondent number 3 is going to the powers appoint any Tom, Dick and Harry.
My lord, may I submit one?
Then?
My lord, my only submission is, my lord, the parent guardian meeting, in that said meeting, the private respondent number 4 and the petitioner herein, my lord, in
Yes, one thing.
27, my lord.
You convene the parent guardians meeting.
Both the
have you direct.
fresh one, yes, my lord, we have no issue. Because that earlier resolution, my lord, that was not as per norms.
My lord, the private respondent number 4, my lord, who is the assistant teacher claiming to be the headmaster now, and the petitioner here in item 27, both the assistant teachers were present in the meeting held in 2nd March 2024. They signed in the meeting. The meeting was convened and passed resolution in presence of both the persons, my lord.
See, one thing, Mrs. Hassan.
Yes, my lord.
The fact remains that meeting has no what do you call it, no force, because this appointment may divorce any seniority, anything. It's just made by the director to look after administration of school. He can appoint even the administrator from the office himself.
My lord is correct, my lord.
I understand that
my lord is correct.
You feel that, oh, you've been slighted because a person who's maybe junior to you in age and joined the same day has been given the post. But that doesn't mean anything.
No.
Let them take a fresh call.
My lord, yes, my lord. In that case, my lord, set aside the impune order and direction may be issued to the.
My lord, continue till such fresh orders are passed,
my lord,
and the managing committee is reconstituted.
My lord is correct, but my lord has to consider one thing, my lord. The impune order was passed by the respondent. He has no power, my lord.
See, we are looking at equity, you're not looking at anything else. This school is stuck now for 2 years now.
My lord, which is why I filed representation. The state respondent is silent on that, my lord.
Now
they have not even replied, my lord.
It cannot
they
be
have
without
not even not intimate.
4.
Yes, my lord.
4 teachers.
4 sanction posts, my lord.
4 sanction.
How many teachers?
Total teachers, my lord. 6, my lord. Another.
How many students are there?
My lord, that position I am not aware.
See, you're seeing a teacher in the school. You don't know how many students.
My lord, I am teacher, my lord. Definitely, my lord. I have to take instruction on the student.
You
my
don't know how
lord.
many teachers, how many students are there.
My lord, since
you're interested in
respondent
your
number
service,
4,
you don't care about the students.
running the school right now as per the impune order. She is the best person to reply, my lord. How many
teachers are fighting among themselves? Who will teach the post students?
They are all fighting for the post, my lord. There is no concern about the students.
My lord,
that's what I've seen all these cases. They're not bothered. They don't even know how many. Do you even know how many students are there?
And moreover, if I'm not wrong, my lord, petitioner is going to retire very soon. Maybe a month. Maybe a month's time.
My lord, 3 months is
3
my
months.
lord. November, in the month of November.
Teacher for 3 months.
3 months, my lord.
Cannot be, my lord.
Which is why
it has to be as per norms. It has to be as per norms, my lord.
Yes, what do you want to say, Miss MS Bharatsaji? In item 27?
27, yes. Item number 27. 309/2024.
Yes. Sultan Mahmud Sakar.
Yes, Your Lordship.
Yeah, for 6. If you are for
And for the state, just one minute.
what number?
1 to 8 years. Here no managing committee here. No 1 to 8.
Yes, same fellow Emmerich.
Yes, 1 to 4, 5, 6 years. 6,
Yes.
7, 8. And 9, 10 are the teachers. There is, in this petition, Your Lordship, there is no whisper of any managing committee expiry or nothing. And case was filed in last year, Your Lordship, before the March expiry of the managing committee. But petitioner is claiming, Mr. Qureshi.
No, I'm not saying. My case is not regarding the managing committee.
Your Lordship.
My case is simply that the impeach order passed by the department is not proper because she is not having a requisite qualifications.
But Your Lordship,
And in spite of that, she was appointed. And being a person and having a requisite qualification, higher qualification, I'm entitled to hold the post of the head teacher. That is my case only.
But Your
That is the prayer only.
But Your Lordship, petitioner has prayed that he is having graduate, he has passed DLED, but only thing is, Your Lordship, kindly have a look at my paragraph 10 of this affidavit, Your Lordship.
Yes. Who are bothered about a qualification?
No, Your Lordship, because he is saying that he is having graduate degree. He has appeared for the graduation exam in Guwahati, 16th April 2025.
So now you're saying you
Yes,
obtain
Your
a degree
Lordship. And
by
on
fraud.
the same date, Your Lordship, he marked as present in the school arrival and so it is fictitious, Your Lordship. It should be brought before Your Lordship.
So same day in two places.
Yes, Your Lordship. Kindly have a look at, Your Lordship, page 18, his annexures. Page 18 of annexure 2 or page 18 of this affidavit in opposition.
Page?
Page 18, Your Lordship.
Mr. Qureshi, better withdraw.
Your Lordship, very bad practice, Your Lordship, because appreciation of facts, Your Lordship, on the same date I have put.
That is
I have
is going to dispose it of with the direction to the.
No. This is separate case, Your Lordship. It should be brought
I'm
before.
misleading everybody. Page 18 where?
Yes, Your Lordship. Kindly check from Monday. Guwahati University admit card, Your Lordship. Monday, April 25th, 2016.
Yes.
Next page, Your Lordship, type copy. I have given page 20, Your Lordship. Kindly have a look. Type copy and original also I have attached.
You didn't attach the type copy.
Type copy also. Kindly have a look at page 20 of the this afternoon.
Annexure 2, page 18 is the photocopy.
18.
You go find exam from April 25, 2016.
Yes.
Okay,
And then next, daily attendance register of teacher at page 20, type copy, Your Lordship.
Yes. Yes.
25, Your Lordship, kindly.
Yes,
Have a
25.
look, 25, Your Lordship. Sultan Mahmud, science teacher, arrival 9 o'clock, Your Lordship.
And level 3 o'clock.
Departure
3 o'clock.
3, Your Lordship. On the same date, how can he be present in two places, Your Lordship?
Maybe we didn't have a paper on that day.
Yes. There may be some mistake.
No, Your Lordship, this is the original register they have provided. Signed by the petitioner itself that he was present on that day and he's having.
No, but then were you doing exams in Guwahati or were you attending class? You were taking classes in where's this district? Where's Garhwals?
But same day, at the same time, Your Lordship, how come it could be?
Someone impersonated you, either writing your exam or
Yes,
teaching
Your
the
Lordship.
students.
That will have to take instruction again on this.
How come this?
Who
After so many.
impersonated you?
No. Last October, I have filed the affidavit in opposition. Now,
Moreover, my learned friend's prayer in his case, my lord, is to consider his to appoint him as head teacher.
And
now there was
Should be appointed,
no resolution in that regard, my lord. If my lord will see the resolution, there was no resolution which was taken.
Such a remarkable person, he can be in two places one time.
Yes.
He can do two jobs same time.
And not only that, Your Lordship, his initial appointment at Annexure 4, page 22, he was appointed by the managing committee, no approval from the
He's
government.
in the fourth
So even
teacher.
the own appointment was
I'm a fourth teacher.
even
So
his
how
appointment
fourth
was
teacher
not
become a
approved.
headmaster of a school, Your Lordship?
He's not the sanctioned teacher.
He is not a sanctioned post.
He's not a sanctioned
Some
teacher.
grant the school is getting. And
No, out of the three sanctions, some amount will deduct and pay to
We
him.
get it. So, Mr. Qureshi, your client very dodgy.
I should take instruction on this.
In 2014,
That time he was just a class 12 pass.
Yes,
Yes.
he
Subsequently,
appointed.
he has got DLED and all. Now these teachers, we have been appointed in 1988, 90.
That time no competition, not competition was
Now he's
done.
coming to say that we don't have DLED, so he's more qualified.
And this degree was obtained, how I do not know how this degree is obtained with the BSc degree, Your Lordship.
Department has to file a grievance show cause if they have
Your
not-
Lordship, why department? Because he
We have
petition.
already filed a representation. Just we filed a representation many times.
Even the petitioner, my lord, in Mr. Hassan's case, he was charged with murder case twice.
No, my lord, my lord,
I
Now
feel sorry
he's-
for the students. What kind of teachers are they having?
my lord. No, my lord. That murder
You've been
case.
charged with murder, with a
Murder,
murder charge.
murder.
No, my lord. That was not proved, my lord.
Not proved means
Read
punishable,
it,
but
read
not
it,
proved.
read from
My
the
lord, he
affidavit.
was acquitted, my lord. After that, my lord, he was acquitted, my lord.
Criminal case is
This is
pending.
the allegation which respondent number 4.
Criminal case is pending, if I am not wrong. my
Respondent number 4 is bringing,
Someone
my
was
lord.
murdered, that's a fact.
No,
lord. Yes,
my lord.
somebody died.
My lord, that is my lord.
attempt to
That is
murder,
a entirely separate issue, my lord. Which is, my lord, he was acquitted in one that criminal case, my lord. Now he is a reputed person. He is
case, my lord. One
regularly
more case is
attending the classes, my lord.
He has
My lord-
even threatened the
No,
earlier
no,
headmaster, my lord.
No, my lord. That is, my lord. That is, my lord, out of the record, my lord. That is, my lord. My lord, I'm
What kind
not
of people,
supposed to, my
I
lord.
feel sorry, again, I'm repeating, what is supposed to, what kind of school is studying in?
My lord.
If a person with a murder charge wants to be headmaster, other person also two places same time wants to be headmaster,
My
how
lord.
is it possible?
My lord, that is, my lord.
But this poor lady, that's why she was made head teacher then.
No, my lord, she was appointed by the director, directly by the
I
director,
think she's
my
not in
lord.
two places at one time and there's no murder charge against you. No. Then
No, my lord, if I say something again, in the ladies, her family also involved in one murder case, my lord. Her family, her husband and his, my lord, that, because I come from that place, my lord. I know personally, which I don't want to submit, my lord. It's a lighter moment, she just, my lord, only contention here is, my lord, the MC is the correct authority, my lord. MC is the person who can verify the seniority, who MC can be find out who is the best for the school, my lord.
no, MC will decide who will be headmaster.
Yes, my lord.
Master is all.
My lord, only difficulty is, my lord, kindly submit, my lord.
Give the code correct dates as
My-
when the last managing committee expired.
My lord,
when
yes,
was
my
it
lord.
constituted, when was it constituted.
My lord, kindly have page 41, my lord. My representation, my lord. Page 41, annexus 7, my lord. Page 41, my lord, in my petition. My lord, paragraph 1, my lord. May I read, my lord? That, sir, the managing committee of Noyagaon government aided UP school, West Garo Hills, had expired on 22nd 12/2023, my lord. That date was in the my lord MC resolution was incorrectly, my lord, typographical error maybe, my lord. The MC was,
There's no documents to show when it was the last reconstitution that
my
approval
lord, that
not
document,
been
my lord,
annexed.
that document is not here, my lord.
You have it with you. Where's the document?
That document I don't have. 12, 12, 23, 22, 12, 23 is correct. But if Lordship is, we continue reading in page 41, this talks about a general meeting of 3rd March 24, not 2nd March.
No, there is two resolution, my lord. Two
See,
resolution.
one thing, Mr. Hassan.
Yes, my lord.
Jokes aside, the only thing is that this court, can you produce it by Monday? I just want the last date of reconstitution. Till the last date, the last approved date, the last legally constituted managing committee, which expired on 12, at least we can go to correct date, when it was constituted and who were the managing committees and members at that point of time. That's what this court wants.
My lord.
You produce it.
My lord, I'll.
You get it by email or whatever.
My lord, the respondent number 3 will be the best, my lord, because
produce
the,
it.
every
In the
papers
course
are
of
not in
hearing,
my possession now.
In the course of hearing, it is seen that the managing committee members of Noyagaon government-aided UP school, West Garo Hills, which had expired on 22/12/2023, as submitted is necessary for the proper adjudication of the matter at hand. Next, Mr. Ensign Leonard G is directed to produce the last approval of the managing company accorded to the said school by the next date. I will dispose it of.
My lord, yes, my
Only
lord.
we need that on record.
My lord.
Just on?
On my
week. Otherwise,
Obliged, my lord.
29.
May it please, Your Lordship.
a school Khasiels are not so devious. These schools on that side are. Yes.
Your Lordship, I have approached before this Honorable Court, Your Lordship, with respect to certain dispute, whereby the year of
Yes.
the year of birth of my year of birth, Your Lordship, at first instance when I joined, I have relied on a school certificate, which the year of birth is reflected as 1967. However, Your Lordship, during the course of my service in the school, Your Lordship, I came to know later on that some of my document which I have relied, Your Lordship, has been tampered with, whereby the year of birth is entered as 1966. And Your Lordship, the document which I have relied is at Annexure 7, page 25. Lordship, it can be clearly seen in the document which I have relied on the face of the record that entry was made by handwritten and overwriting, which is reflected as 1966 and not as 1967. Your Lordship, during the course of my service in the school, last year, Your Lordship, in August 2024, my salary was denied and stopped by the government, by the state respondent. And
Only one question, Mr. When did you come to know about this tampering?
Lordship, we came to know last year when my salary was stopped. I was not informed, or no notice was given to me, Lordship, and there has been a violation of the principles of natural justice to inform me. So, Lordship, upon learning of the entire circumstances of the change of date, later on in the month of October, Your Lordship, I approached the school to rectify and to make corrections of the year of birth in the service record, and later on to the state respondent, Your Lordship, to the SDSO to change the name. However, Your Lordship, I was denied.
See, one thing, Mr. Where's that she had shown last time? Service book in the affidavit?
In the affidavit of the state, Your
Your
Lordship.
Lordship, if I may, Your Lordship.
No, where you had shown last time, remember the affidavit?
Your Lordship.
It's Annexure 1, page 9, Your Lordship.
Of the affidavit.
From the affidavit filed by the state.
Yes. So, Mr. Lindo, where's the date of birth here? 9-3. Date of birth 26/8/66.
At the date of joining, Your Lordship, I have relied on the school certificate issued by the headmaster of Shangpung Presbyterian School, which is 26 August 1967. And in support of my document, Your Lordship, which I have relied at first instance, Your Lordship was pleased to allow me to file an affidavit to bring on record the matriculation certificate, which I have obtained. And that is in my rejoinder, Your Lordship. Annexure 1, which is at page 7. And on the last date, Your Lordship, we have placed before Your Lordship the original copy of the admit card, which I have obtained from the emboss.
This is the original admit card, or it was obtained later on?
It was obtained later on, Your Lordship.
Then, when was it obtained?
When the instruction received, Your Lordship, it was obtained. We did try to obtain prior to the entire issue.
Original admit card, but
No, Your Lordship, it is a duplicate copy. Your
At first instance, we did not submit anybody. Have obtained a duplicate copy from.
after the case was filed.
Yes, Your Lordship, during pendency. And certain instruction was given by the state respondent in July, Lordship, if we have any document to substantiate the year of birth of my year of birth, Lordship, then I can submit. Lordship, the entire matter is that when the salary was stopped by the state respondent, this entire issue when I came to learn of the entire circumstances of the change of the year of birth in my service record and the entry made in Annexure 7, Your Lordship, which I have relied in my main application. Now, Your Lordship, in the affidavit which the state they have filed, they remain silent on this document which I have relied as Annexure 7, where there has been some tampering and overwriting in my year of birth. Which is at page 25, Your Lordship. And Lordship,
But one thing, who's going to ascertain that now? Because as per the respondents will rely only upon the service book.
Yes, Your Lordship.
Yes.
Lordship, I came to learn during pendency of my entire service serving the school for the last 30 years of the circumstances that the year of birth has changed. It was not within my knowledge. And upon having the
You
knowledge
have the
of...
authority. Last time you supposed to bring some authority.
Yes, Your Lordship.
May I please, Your Lordship? Your Lordship, this petition is liable to be dismissed on the ground of delay in natures, Your Lordship. Why, Your Lordship? Because the petitioner had joined service in 1987, Your Lordship. Now they had produced this school leaving certificate issued not by the board but by the school authority.
When?
During, most probably during entering service, Your Lordship. Now, if we look at the service book, Your Lordship, that is an extra one of my
Yeah,
affidavit.
they've seen the 67.
Yes, Your Lordship. There's no tampering, Your Lordship. It's 1966.
No, when was this produced? This is at time of joining.
We don't have records of that, whether it was produced or not also, Your Lordship.
Where do you get this from? This is with your... It was submitted according to you at the time of joining.
No, Your Lordship, I've submitted the actual copy which I have, Your Lordship, which is at Annexure 3, page 16. This is the actual copy which I've submitted at the time of joining, Your Lordship.
And Your Lordship, if he's talking about tampering, Your Lordship, then this will raise disputed question of facts, Your Lordship.
No, see, we'll limit only to one thing. The thing is that you realize that your date of birth was tampered, according to you, allegedly tampered, only after the salary was stopped.
Yes, Your Lordship.
No, Your Lordship.
How do you realize that?
Lordship, I did not get any payment from September 2024.
You don't have access to your service book through your service career.
No, Your Lordship.
You don't have.
Lordship,
Then
upon
how do you
instruction...
fill nominees? Have you filled with your nominees?
No, Your Lordship. The preparation for the pension papers has been
Your service
initiated
book
now.
was not to your knowledge at all throughout your service career.
We have the knowledge, Your Lordship, but within the respect of the entry made with the year of birth, we do not have any knowledge.
See how is date of birth corrected? Sometimes by looking at service book, an employee realizes that, oh, but it has been done at least 2 years before you retire, or at least 1 year.
Yes, Your Lordship.
At least, or the wrong entry is there. Then you represent. Then you supply testimonials and other documents.
That was not complied with, Your Lordship, by the state.
If I may, Your
by the head
Lordship,
of...
I'll just take you to para 6 of their writ petition, Your Lordship. Para 6 of their writ petition. I'll just read, Your Lordship, that the petitioner, sometime in the month of November 2019, on her official visit before the office of respondent number 5, inspected her service record and came to the knowledge that the year of birth of the petitioner has been tampered with in the service data records maintained by respondent number 5 by overwriting in the year of birth as 26/8/1966 instead of the actual and correct date and year of birth 1967. Further, it was learned that the school certificate dated 23/4/1987 was reproduced and retyped by unknown person and the year of birth was overwritten as 1966. Furthermore, signature of what was put on the face of the reproduced document. The reproduced document was prepared and made behind the back and without, Your Lordship, she came to know in 2019, Your Lordship. And Your Lordship, she did not approach. She was sleeping over her rights, Your Lordship. She came only 2 months after retirement, Your Lordship. 2 months after retirement. Even the rules, Your Lordship.
The entire circumstances of the situation.
The court just have a pointed question to you whether they had access to your service book or not. You said no, we don't know. But then in your own affidavit, you said you've seen in 2019.
Yes, Your Lordship. Your Lordship,
whatever it is, you might have a case was too late. Let's see what authority you have. You have the authority.
I've already given my list of books, Your Lordship.
Okay, you cite authority. Let's cite authority.
Your Lordship, if I may, even the service SR-FR rules, Your Lordship, the note appended to SR-8 of FR and SR rules 1984 states that no alteration in the date of birth of a government servant should be allowed except in very rare cases where a manifest mistake has been made. Such mistake should be rectified at the earliest opportunity in the course of periodical reattestation of the entries in the first page of the service book. In no case, request for change in the date of birth of a government servant made on a date within 3 years of the date of his actual superannuation should be entertained. Now, their first communication was, Your Lordship, their
25.
first communication was Annexure 10, Your Lordship, 17/10/2024. 2 months, almost 2 months after their date of retirement, Your Lordship.
Yes. That's the only thing, whatever.
Yes, Your Lordship, I have certain points of which I would like to rebut on that issue.
No, you just, what authority you have?
Your Lordship,
Judgment open court only, yes. You still have time.
Your Lordship, with respect to matriculation certificate, which I have relied upon, Your Lordship, which is reported in AIR 2016. AIR 2016, Your Lordship. Lordship, the judgment I'm relying upon, which I've handed over, Your Lordship, this is from Jharkhand High Court, which is having persuasive value in the entire claim. Lordship, observation was made.
No, that is, see, matriculation certificate is taken to be the correct date of,
yes, Your Lordship.
Of birth. Okay, you have not produced, but out here you produce only your school leaving certificate and your admit card subsequently.
Yes, Your Lordship.
Correct.
Yes.
Right.
Now, Your Lordship, there has been judgment by the Honorable Supreme Court, which say, like, at the fact end of the service, I cannot change, but the entire circumstances of.
You cannot, that is the law.
That is the law, Your Lordship.
But
Your
then,
Lordship,
but then everyone will come, you see, you can't open flood. That is why this is only we're looking at these special circumstances because you had alleged tampering, that is court's hearing. Otherwise, you come in normal course for correction.
Your Lordship, and apart from my claim, Your Lordship, with respect to the change of the year of birth, Lordship, with the pension papers which they claim at first instance, when we move that, it's already been prepared. Your Lordship, however.
See, the only thing is that defeats the whole case is, what is that paragraph?
6.
Para 6, Your
My.
Lordship.
But Your Lordship, in respect to the norms and the rules, as per the pension rules of the state, Your Lordship, 1983, where it has been clearly mentioned that 2 months prior to my retirement, the preparation of the pension papers should be
That was
complied
prepared, Your
with.
Lordship. We've already stated
However,
in
Your
our
Lordship,
affidavit in
there has been a new
opposition.
development whereby today was given to the petitioner to me to sign
Nothing as
papers,
such,
Your
Your
Lordship.
Lordship.
Your Lordship,
On
I have
17 January 2024, we had already prepared a list.
FR 8. No? Yes. So what judgment do you rely upon? FR, does FR FR is SR8.
SRS of FR and SR rules 19.
SR8.
The note
It's
appended,
SR8,
Your
Your
Lordship. SR8.
Of the 1984 rule of the state.
Yes. Yes. Take down.
Your Lordship, I have. Let me apprise Your Lordship. One is having persuasive value, Lordship, which I'm relying again on the matriculation certificate, whereby.
Does the matter be from Jharkhand?
Chhattisgarh, Your Lordship, High Court of Chhattisgarh.
Where's the citation of MS Lingua?
Your Lordship, I've already.
Your Lordship, at page 17, paragraph 28.
Yes.
Where it's highly stated, Your Lordship, amongst of the paragraph which I'm relying upon, Your Lordship, in paragraph 25 was where clearly certain judgments of the Honorable High Court was relied upon, where in even of any other error in the service record, Your Lordship, but there should be a proper evidence in support of my entire claim in order to support my own case for correction or rectification of the birth certificate. Your Lordship, there are certain cases which the Chhattisgarh High Court had relied upon, Your Lordship, with respect to service matter with change of the date, whereby it has made the observation in paragraph 28, where the employer can take records of correction of date of birth of its employee, but he should be in possession of satisfactorily admissible and irrefutable piece of evidence with
What
him.
goes against you, this para 26?
Your Lordship, I'm relying on 28, whereby apart from the observation, the conclusion made, Your Lordship, the observation.
But it goes against you.
Yes, Your Lordship, but the circumstances here, Your Lordship,
The
matter.
The other case is actually covers your case.
Yes, but Your Lordship,
you're given your opportunity to correct anyway.
Your Lordship, the circumstances involved in the case, Your Lordship, where it may not be in a similar nature, but this is the the first of its kind that happening before the state, Your Lordship.
Yes.
But on the other part, in the end, Your Lordship, which I have relied upon heavily on the matter of preparation of the pension papers. Lordship, as per the norms and the OM which I have relied in my rejoinder, that
That has no relevance, Mr. Rino.
the Lordship,
The whole issue is whether it's a correct date of birth. When
the
it's
Lordship,
prepared
recent
and how-
development which we have received from the office.
Even if it's 6 months, that time is beyond the window allowed for correction of mere representations.
Lordship, there has been gross violation of with no communication or notice being served to me, Your Lordship.
If I may, Your Lordship, I've just received a letter, Your Lordship, from the department where they had requested the petitioner to come to office in person for
This is the
preparation
new
of pension.
development, Your Lordship, which I'm relying on. We have just received it.
They're already preparing the
Yesterday,
pension
Your
papers,
Lordship.
Your Lordship. It's already reached its final.
This is the entire circumstances, Your Lordship, which is against the rules and norms of the pension rules 1983 of the state. Yeah.
Yeah.
And Your Lordship, in the affidavit which I rejoinder, Your Lordship, which I have filed, I have relied on certain office memorandums from the pension cell.
Those have no relevance, Mr. Only we are limiting only, not forget my pension only on the aspect of your application correction of date of birth. That's all. All others are consequential.
Mr. Lordship, but the
Having
ban.
preparation pension papers, how many pension cases are pending here? Where people,
Yes. Your Lordship, yes.
It's
Your
not.
Lordship, the circumstances involved in the case
It
should
will
not
be
be
a
repeated.
factor that will not be a factor that will allow the response or to give you, any vested right to see the date of birth to be corrected. Delay in payment pension. Yes.
But Your Lordship, amongst other grounds and causes which occur to the entire circumstances.
Your para 6 finishes the whole case. Let's take down the petitioner by way of the instant writ petition. Let's come before this court with a prayer to make the correct entry of the year of birth of the petitioner in accordance with the school leaving certificate and for other appropriate rules, orders and directions. To issue to the respondents in connection thereto. Next paragraph. The brief fact of the case is that the writ petitioner was appointed as a lower primary school teacher where appointment letter dated 28/09/1987 at Shangpung Poshnong Lower Primary School, and thereafter has been serving the school till her superannuation.
No, Your Lordship, at first instance she joined this Poshnong and presently she is at Ninchnong Lower Primary School.
Joined service, no, he joined service. In 1987 at Shangpung Poshnong Lower Primary School and joined service therein on 29/9/1987. Then, what do you say? Then you transferred?
Transferred, yes, Lordship. Is that paragraph number 4?
Thereafter, was transferred to Shangpung Nengshnong Lower Primary School in the same post till her superannuation. Stop. The grievance writ petitioner is that her actual date of birth is 26/8/1967, whereas the same has been recorded by the respondents as 26/8/1966. Stop. She submits that due to this error that has occurred, the petitioner has been deprived of a full year of service along with the attendant benefits and salary. Stop. Next paragraph. Mr. S.R. Lingdo, a learned counsel petitioner, submitted that the petitioner's case is founded on the fact that the school leaving certificate dated 23/4/1987, which had been submitted to the respondents at the time of joining, has been tampered with by unknown persons. And have been tampered with by whom?
We do not have any knowledge.
But tampered with and have been tampered to show a date of birth as 26 August 1966. So he submits that further, though efforts have been made by the writ petitioner to get the same corrected and a duplicate admit card, duplicate arbitration admit card also obtained to substantiate this fact, the petitioners have proceeded with she has been she has been superannuated, and also the process has also is nearly complete for payment of a pension.
Your Lordship, as per the letter, it's preparation and they call me to
payment of pension. So he submits that the writ petitioner was never afforded adequate opportunity to present her case, nor was she informed about the change in the date, nor was any action taken on the allegations of tampering. Stop. To substantiate, to support his arguments, not support, to buttress his arguments with regard to the fact that the school leaving certificate is the correct indicator of the date of birth. The learned advocate, learned counsel has placed reliance on this one for judgment number 1, and with regard to correction has placed reliance on the judgment in number 2, which is judgment rendered by stop. Next paragraph. MS Lingma, then it.
Lordship, if I may.
Yes.
Lordship, at first motion, when I motioned the case before your Lordship with respect to the delay since November 2019, I've made my statement and submission that after November 2019, what followed was 2020 during the COVID period, your Lordship. So there were some lapses of which, and being an elderly, your Lordship, and so there has been some lapses where
2021 you came to court 25.
Yes, Your Lordship.
Yes, your Lordship.
5 years, Your Lordship.
But your Lordship, as of
We can't blame you, Mr. Dingro. You've tried.
Yes,
of course. That's you.
But your Lordship,
do the best of your ability. You've tried. So at least
Lordship,
your client will realize that. That's all. Yes.
But your Lordship, under the circumstances of the matter,
Yes, we understand. We'll record that. MS Lingma, learned GA, in reply to submissions made by the learned counsel, has submitted that the writ petition on the face of it is not maintainable. It does not deserve to be entertained in view of the latches and lapses on the part of the petitioner in seeking remedy. Stop. The Learned Counsel has drawn the attention of this court to para 6 of the writ petition, wherein it is stated that the petitioner had come to the knowledge of the purported incorrect date in November 2019 itself, and has only approached this court in the year of 2025 for correction. He submits on the ground alone the writ petition deserves dismissal. Stop. Another limb of argument, the writ petitioner has referred to the note which is appended to SR 8,
Your Lordship.
which provides that no alteration in the date of birth of a government servant should be allowed, except in very rare cases where manifest mistake has been made, and that this mistake should have been corrected at the earliest in the course of periodical re-attestation of the entries in the first page of the service book. Stop. He submits that in the instant case, the entry in the service book of the petitioner clearly shows the recorded date of birth is 26/8/1967.
1966, Your Lordship.
1966, and as such, at this stage, there is no scope for correction of the date of birth, even if the documents as produced are genuine, are stated to be genuine. Yes. What judgment right upon?
Your
Any other
Lordship.
submission? No.
Your Lordship, I've produced
Where's
5
the
judgments, Your
judgment?
Lordship.
5 judgments?
Yes, Your Lordship.
What does the first judgment say?
Your Lordship, in 2020, this is Bharat Coking Coal Limited, para 7 to 14. Your Lordship, para 7 talks about the the metric certificate. Yes, Your Lordship, certificate. If it has not been brought on record, Your Lordship, it cannot be considered, Your Lordship.
Where para?
Para 7, Your Lordship. The fact that the respondent had joined the services of the appellants on 1st May 1982 is the accepted position, though the respondent relies on the matriculation
You didn't produce it at the
certificate.
time of joining?
No, Your Lordship. We don't have any records, Your Lordship.
Okay, she, in support of her arguments, the council has placed reliance on, firstly, the case of so-and-so reported in 2023 SEC 411, wherein it is held that the documents stated which the petitioner seeks to rely should have been, which a person seeks to rely upon should have been produced at the time of joining employment. Next one.
Para 9, Your Lordship. The request for change of date of birth in a service record at the fact end of service is not sustainable.
She further submits that she submits further held the judgment that a request for change of date of birth at the fact end is not sustainable. Yes. This is a settled law.
Yes, Your Lordship.
And next, the
para
judgment?
10 also, Your Lordship.
Para 10 also?
Yes, even if there is a good evidence to establish that the recorded date of birth is erroneous, the correction cannot be claimed as a matter of right, Your Lordship.
Yes. Omno? And that even if there's good evidence, even if there's good evidence to establish that recorded date of birth is erroneous, she therefore concludes submissions that the petition being hit by delay and in the absence of any relevant material, the same may be dismissed. Yes. I've heard the counsels for the parties and I've considered the materials, I've considered the submissions and the materials as placed.
Your Lordship, if I may, at first instance, when I motion as well, Your Lordship, I have placed reliance on the list of the government servant due retirement.
Mr.
So that
we can't allow
that
this.
has not yet been.
Here we can't, as much you would want to give relief, law does not permit. Yes,
Your Lordship, but there's a mandate of the rule, Lordship. I have made.
Yes, take down. You appeal.
I've pressed for.
Yes. Yes, please stop. It is noticed that the petitioner, throughout her service, though undoubtedly having access to the service book, wherein the date of birth entered has not raised any questions till the time has come for her to superannuate. Stop. This fact is evidenced by the statements made in para 6 of the petition itself, which is
in paragraph 7, as well as mentioned,
which is where it is stated that the petitioner sometime in the month of November 2019 or before the office of the respondent 5 inspected her service record and came to the knowledge that the date of birth of the petitioner had been tampered with as alleged stuff. This fact was not denied by the petitioner. Oh, sorry. If the same is correct, the petitioner, if genuinely aggrieved, should have taken immediate steps to get the same corrected and or to provide other supporting materials before the respondents to enable them to conduct an inquiry to verify the veracity of the documents that have been produced. In the instant case, however, the petitioner stepped over her rights, if any, by agitating her case only when she was superannuated.
Yes, Your Lordship, 2 months after.
And when my salary was stopped.
2 months
Yes.
after she retired.
Yes, Your Lordship,
So
2
he
months
said, no?
after her
Yes,
retirement.
2 months after the date of retirement. So, in these circumstances, without dwelling upon other facts, as it is settled law, that correction of the entry of date of birth cannot be permitted at the faggot of service, and purely on the question of delay and laches.
Lordship, would matter concern in conjunction with paragraph 7, Lordship, I have made the statement in my pleading, Your Lordship, with respect to the delay.
The petition is yes.
Lordship, in paragraph 7, I make a statement in the pleading of the delay, why the delay was there, Lordship. So we're still awaiting communication from the state respondent.
Where's that?
Your Lordship,
Paragraph
they
number 7,
never,
Your Lordship.
Where's the letter?
communicated
Where's the
in the
letter?
first place, Your Lordship.
Where's the letter? Show the letter. Have you looked for a letter, Mr. Dingdo?
There's no,
Where's the letter?
there's nothing on record, Your Lordship.
We're waiting communication
No,
from
where's
the state
letter? Where's
respondent.
the letter 19 which you wrote?
There's
We're
no
looking
such
for the
letter,
letter.
such, Your
See,
Lordship.
if you'd only given a letter, where's the letter?
The letter was given a later stage, Your Lordship, on that. So,
No, where's the letter 19?
Your Lordship, the statement through which, as per the instruction received, Lordship, that is entirely like my.
Fairness, because even if there's conclusive materials that might be, even if there are materials that can be taken into account for determination of the same stuff. Further, as provided in SR 8 or the note thereto, it's not necessarily to the petitioner should have represented well within time for correction. Stop. It is further also noticed that as submitted by the Leonard GA, no materials have been produced by the petitioner to show that she had ever represented or that the school leaving certificate which reliance has been placed upon was ever produced or submitted at the time of joining service. Something like in these circumstances, the petition deserves no further consideration, and the same is dismissed. Yes.
Highly obliged.
Obliged, Lordship.
What is wrong with you? You're so difficult.